McGlynn ending his comments in court on Thursday by displaying a picture with an arrow pointed to it, surrounded by debris, a building. And that building just happened to be the courtroom everyone was sitting in there on Thursday as Judge McGlynn talked about the 1917 race riots. That's how he ended the bench trial in the ban challenge of Illinois' Protect Illinois Communities Act. So you've got this law that was put into place January of 2023. Lawsuits filed thereafter in state courts, but the federal lawsuits, they are sustained throughout, going through preliminary grounds all the way up to the 7th Circuit, even all the way up to the U.S. Supreme Court, saying the case isn't ripe yet. Goes back to the district court, and the district court working to build that record as to answering what the 7th Circuit Court of Appeals had to say. AR-15s, too similar, too adjacent to military firearms. So we had a 4-day bench trial in East St. Louis, and let's get right on into it. As we've got the live stream giving us some hiccups, but have no fear, we'll be back at it. And of course, we re-upload the locally recorded segments so you don't miss a thing. All right, so if you do get held up with the live stream, don't worry. We'll be back with, obviously, the full upload. All right, so let's get into this, all right? I was in the courtroom each and every day, day 1, day 2, day 3, and it's kind of fascinating, again, to be watching all of this happen. But what we're going to do is we're going to pull up the X page, and we're just going to go through this together, all right? So here we are. Bench trial for Illinois' gun ban begins. Day 1, live posts from the Southern District Federal Court. Follow this thread. Court now in session. Judge Stephen McGlynn presiding. Barnett v. Raoul litigants announced their presence. But it wasn't just Barnett v. Raoul. You had Harold v. Raoul. You had the ISRA as part of that case. You had the firearms licensed FFLs there. You had a variety of different cases, 4 altogether consolidated. So one attorney announces several others. They went to go get Wi-Fi. McGlynn asked, they went to get a glass of white wine. The courtroom laughs, no objection. He says, so clearly a little bit of levity right at the start of the case. McGlynn opens, designates lead case to the Barnett. Barnett's attorney speaks on behalf of all plaintiffs. Says that the state enacted an unconstitutional gun and magazine ban. The law doesn't stop there. It also bans popular shotguns used for duck hunting. These are popular firearms, the plaintiff said. Scope's limited. Historical tradition based on briefs. Standing is based on the briefs. What arms are is to be considered. And I think this is important to note here. What the arms are to be considered was military versus, civilian grade. The historical standing and the precedent and the Second Amendment and all of that was being relegated to just the briefs. So what was being talked about in court for the 4 days really was about distinguishing military-issued rifles versus rifles that people can buy at a gun store. Anyways, Barnett counsel lays out firearms attachments to be considered, says while some may be used by police and military, they have dual use, and Second Amendment comes in. Quoting McGlynn from an order he had back in February in this case. Then the plaintiffs lay out what's to expected from live testimony, including Pulaski. Scott Pulaski, owner of Piasa Armory, says it's important to hear from Illinois resident impacted by the gun ban, says the state's witnesses doesn't have a single Illinois resident. The plaintiffs continue. Previous declarations have been filed, trial exhibits on a jump drive, including discovery records, etc., exhibits, live testimony to support the plaintiff's case, arms covered by the Second Amendment and historical precedent, don't need witness to tender those, the Barnett attorney says. At conclusion of live testimony this week and post-trial submissions, including Supreme Court of the United States, Barnett attorney urges McGlynn to find the gun ban unconstitutional and to enter a permanent injunction against Illinois' gun ban. So that's the opening statements from day 1. The opening statements from the state as defending the law, they went to the podium and they said that Illinois residents have testified to this through state legislature action after the 2022 Highland Park parade shooting by pushing for a gun ban to be law. So the state said, yeah, we may not have any Illinois residents testifying at their trial. They do have the state legislature speaking for the people in this. So the state continues on. They say the appeals court sided with the state that they would likely succeed, and they say the ruling should find AR-15s should be banned. And I'm looking at the live stream, and it is completely dropped off. That's awesome. Still doing it. It says appeals court found M16s can be banned and AR-15s are similar, just not able to go full auto. Claims that Heller finds such firearms can be banned without running against the Second Amendment. So the state continues on and lays out expected testimony from former military about M16s. So state defense, you'll hear soldiers and Marines trained to shoot and train in semi-automatic because it's more accurate, the state says as defense. They go on to say that evidence shows difference between an M16 and an AR-15 is immaterial. So again, the state's making these opening statements here saying that any difference between the M16 and the AR-15 is immaterial. Says that marketing shows nothing about how people can defend themselves. Also says that the numbers only test isn't right. And then says doesn't show how they're being used. So there was a lot of conversation later on we'll get to about comparing the manufacturing numbers and such. Looks like the live stream went back live. All right. So state defense addresses expected plaintiff's witness, says they must show how such firearms are used for self-defense. Even if the case is about numbers, evidence shows they aren't being used for self-defense, the state said. They went on to say that evidence will show appeals court got it right. They say that the ban is consistent with historical tradition, that military-style guns being banned is constitutional. So that's the opening from the state that followed the opening from the plaintiffs. So now it's time for the first witness. Again, we're in day one here. Time for the first witness. Scott Pulaski called. He's sworn in, says that he's an Illinois resident, owner and creator of Pulaski Armory since 2012. Principal decision maker in the company, says that he sells to the general public since 2013, since they've been licensed. He says he has 6 employees, says that he has the final decision on which firearms to obtain for sale to the general public based on customer feedback and customer needs. Plaintiff's attorney pulling out exhibit number 47. And again, they have all these different exhibits they would put up on a screen so they could discuss a variety of things. And all of these exhibits as well being filed through the court. Taking 10-minute recess after the first exhibit to work out a technical issue, so they had to get the tech guys in there to sort that all out. So they sorted that out. Bench trial resumes. Plaintiff's witness, Pulaski, to resume testimony. McGlenn puts case back on record. Plaintiff's attorney shows exhibit 47, a declaration filed by Pulaski Armory that lists banned firearms that were sold before the ban. Pulaski says the ban restricts sales of items based on features, etc., that he made the decision to comply with the ban to keep his license. He says that he does sell banned firearms to exempt persons like active and retired law enforcement, about one a month, he says. Shows Exhibit 191, texts of the Public Act for the Gun Ban, Protect Illinois Communities Act. They focus on the grip area in their search of the document and other definitions like semi-automatic accepting detachable magazines with various features. Any sales prior to the ban? Yes. After the ban? Yes. During that 6-day injunction last year, if you recall. Brief background. Preliminary grounds on this case. You did have the Judge McGlenn here issue a preliminary injunction that lasted 6 days, late April into early May, before the state got it up to the appeals courts and they put a stay on that preliminary injunction. A stay meaning the injunction was not going to be effective until they figured it out. And then they held their hearing in the appeals court, sided with the state, reversed the preliminary injunction, and we know the history now goes all the way up to the Supreme Court. They say the case isn't ready yet. Now it's back in the district court, and this is where we're at now. Day one testimony, rough outline. And here's something else too. We're not going to get the actual official transcript. Just a brief moment here. We're not going to get the physical transcript from the court until December. And I think that's why I wanted to go through this in some detail. It's going to be a long video. All right, I know that, but I wanted to give you guys that rough transcript of me being in the courtroom, feverishly going on my phone, posting updates, okay? Because it's going to be until close to, well, close to mid-December before the transcript's actually released from how I read it. But anyways, let's get back to the posting here. And again, you can see all of this yourself at Bishop on Air. I may go ahead and link day 1, day 2, day 3, day 4 in this video in the description, just so you can have easy access to it. But anyways, they focus on the various things. Says, yes, they did sell after the law was in place during the 6-day injunction last year. Pulaski said they sold several thousand during the injunction, and customers picked up several thousand that were sold before the ban took effect. Says that he keeps detailed records of sales, and then they show Exhibit 46, covers the ATF bound book. ATF bound book details where firearms came from, who buys. It's all for investigative purposes. Shows the second page with the chart showing separate firearm transactions, several redactions, including the serial number, names, addresses, notes. It gives a breakdown of sales versus transfers. Pulaski discusses the process of logging firearm inventory, transferring sales, and so on. Record-keeping system identified, back to Exhibit 46, page 2. The date of disposition, the ownership transfer to final destination, Pulaski said. Highlights entries not in chronological order, and discusses the generation of the document. Attorney shows documents go from 1,240 pages of records from January 2021 to April of 2024. Multiple transfers and sales per page. Pulaski doesn't handle privately made firearms, they said. Parameters for manufacturer determined by the ATF. Type, model, gauge, country of manufacture. No entries there, but he said that it wasn't used by Pulaski. Serial number column redacted. Date of import column explained. Name of license or non-licensee columns redacted. Date of disposition explained. Name, address, and notes columns all were redacted in this public exhibit that they showed in federal court. Pulaski explains redactions for courts to protect privacy of the transactions. In normal course of business, those redactions are not made. Other than the redactions, no other alterations to the document, Pulaski said. He went on to say that he can identify AR-style rifles by make, caliber, including lower receivers. He says he's aware of receivers being made into rifles as customers bring them in to show that they've built them. He identifies AR-type rifles in the ATF bound book on page 3 that they had pulled up. He explains 5.56 NATO rounds being entered into the details and different types of ammunition for AR rifles and receivers. The plaintiff's attorney searches 5.56 in the document, finds other entries with different manufacturers. Search function shows 415 different entries for 5.56 in Pulaski Armory's ATF bound book exhibit. The attorney continues to find different manufacturers. Other entries show 5.56, but not all are AR style. Some are pistols, but still restricted by Illinois' gun ban. McGlynn says this isn't a jury trial, and they've proved there are a ton of manufacturers. McGlynn says, interrupting the first witness here, where are you going with this, to the plaintiff's attorney? Attorney says that is the point, and they continue to find examples of different manufacturers. Pulaski says that there are dozens, if not hundreds, of manufacturers of AR-type rifles. Many of them Pulaski does not sell. Counsel asks about other information that's collected, transfer of pistols and concealable firearms. Pulaski said the state requires other info if you are buying a concealed firearm, like your occupation, also the price, and the reason for the sale. Pulaski says they review such information for if someone discloses criminal intent. None have, he says. Some reasons are AR-15 is for self-defense. This is where the defense, the state, objected. They said it's hearsay. McGlynn fires back and says overruled. They go through again. Why are people buying these guns? Mostly for self-defense. Then objection from the state again. McGlynn says the info discussed is required by law and reason for purchase is not inadmissible. Objections overruled. So that's the first time that we saw the state try to object to the plaintiff's testimony, and McGlynn overruling the state in that testimony. Pulaski says reason given for self-defense or personal protection, collection, sport shooting, other lawful reasons given for purchase of AR-15 is common. Plaintiff's attorney asks Pulaski about box magazines, which are restricted by Illinois law. They're regularly sold, he said. Hundreds per year are sold. Discusses the need for the firearm owner's ID card from Illinois residents. Only sells around 15 a year to out-of-state residents. Prior to gun ban tracking effect, Pulaski said that he kept semi-automatic rifles now banned. He says that it'd be regular inventory, kept several in stock at all times. That's what customers wanted, half a dozen to 10 on hand, but they're not kept in inventory anymore after the ban. Pulaski says competition also sold semi-automatic firearms in box magazines before the ban. Since the ban, Pulaski says he regularly turns down sale requests for banned items, including an AR-style rifle or a twice a month, one or two a month, he says, as customers don't know about the ban. So people come in, they say, I'd like to buy an AR, and they have to say, no, there's a ban in place. Same for those seeking box magazines. Pulaski says he's not being paid to testify. Plaintiff's attorney finishes questioning for Pulaski. Time for cross-examination from the state. So this also, I hope, gives you kind of a little bit of insight on the importance of a bench trial, right? This was a 4-day bench trial. We're going through just day one of the bench trial of the gun and magazine ban. I'm going to go through all 4. It's going to be a bit of a long video, okay? But we're going to go through all 4 days here. But you had a witness, the plaintiff's direct examination, and then you get cross-examination from the defense, and then you get redirect from the plaintiffs again. And then the judge asks his own questions at the end of each witness. So that's kind of the platform or the protocol, right? So the litigant brings their witness, direct examination. The opposite side has cross-examination. Then the person who brought the witness gets to redirect, and then the judge can ask questions. So that's just kind of the outline, so to speak. So back to it. The defense on cross-examination, they focus on assault weapons. In the ATF-bound book, Pulaski says that he can identify such rifles classified as assault weapons by Illinois' gun ban, notes that magazine capacity isn't always noted in the sales, and discusses sales to law enforcement agencies and exempt individuals, though redactions wouldn't note that or note gunsmith services, Pulaski says, are around 300 to 400 a day. Defense asks about other forms that customers fill out for the reason of purchase. Pulaski said the state required info verified like address, no way to independently verify the reason for the sale, the defense got Pulaski to say. Defense also asked about 50 caliber sales, about one every other year. Can't recall the sale of a pistol with attached magazine, about 15, and only one grenade launcher transferred in business history. Defense discusses Pulaski, not an expert in statistics. Defense takes a moment to confer with colleagues, and they say no further questions. The plaintiff's counsel returns for redirect. Plaintiff's attorney confirms no ban-compliant AR-type rifle sold. Very rare. Very likely that all such rifles in the bound book are now banned. Asked about sales to exempt persons, defense objects. That question not based on cross-examination. McGlynn overrules that. So again, I think it's like 3-0. The state tried to object, but McGlynn overruled that objection. Pulaski goes on to say about 1 month, one a month he discusses gunsmithing and so on. McGlynn then gets to ask Pulaski questions. Do people ask for advice? Yes. Carry firearms with camo? Yes. Gunmetal blue? Yes. Like Grandpa's shotgun? Yes. Shooting range? Yes. Gun shows? Nope. State compliance form you created to compile with data to provide to the state? Yes. Notify about need for background check? Yes. Can't leave the store without a waiting period? Yes. State form you ask for info? No sale without FOID card? Yes. Can be denied? Yes. Concealed carry training? Yes. On form, get ID, background check, occupation, whether captain of industry or homemaker. Yes. Then McGlynn says, reason for purchase asked because of the law. And Pulaski says yes. McGlynn continues questioning Pulaski. Men, women, disabled, do they buy? Yes. Reasons given for self-defense and hunting, etc.? Yes. What about AR-15 reasons? Exempt from work? Others, they use it for self-defense? Yes. Is that common? Yes. Reason only for concealable? Yeah. Pulaski indicates they expanded that to all sales to be sure. Quote, if someone would walk out of our store with a firearm, they should have FOID, ID, name, occupation, reason, and background check. That's correct, Pulaski said. So the judge then says nothing further. More cross-examination. The defense says yes. So they hopped up and they asked about advice to customers, and they discussed Glock 19, standard 15-round compliant with ban. Pulaski says accessory mag is 17, and that's banned. Discusses other recommendations of rifles for self-defense. Any 50 caliber recommendation for self-defense out of price range. Belt fed for self-defense. Again, Pulaski says that's out of the price range for most. And then they say nothing further. The plaintiff's attorney returns for more questions of Pulaski. The plaintiff's attorney makes points that looking at the list of dozens of manufacturers only make AR rifles. Nothing further. Then McGlynn asks about the 50 caliber rifle and pistol. Quite the recoil, no. Pulaski says yes. Most people can't control because of the real kick. Correct. No one asked for 50 BMG for self-defense. Langley plaintiff attorney Thomas Magg, he clarifies that only 50 caliber BMG is banned. Plaintiffs move exhibits used for the questioning to evidence, and now it's time for the next witness, but McGlynn wanted to take a break, so court was in recess. I was able to talk with Scott Pulaski, and you can watch that video as well on this feed, but then we continued on in the afternoon session with Jeff Eby. That was a plaintiff's witness. He prepared a report for the case per plaintiff's request, showing Exhibit 1, that's the report. He says he evaluated the weapons banned and whether they were fit for military service. Again, what this case really comes down to, at least the live testimony, was looking at what's banned and whether or not the Seventh Circuit Court of Appeal saying that these banned firearms are too similar to military rifles and they should be banned. That's the crux of the live testimony here. So continuing on. Eby also prepared a rebuttal report to critique other witnesses. Eby was a Marine gunner in the Marines. Speaking too fast for court reporters, the courtroom laughs and explains slowly what a gunner is. State defense, they object to the amount of detail in the answers from Eby. The judge urges Eby to focus on the questions. Eby says, yes, sir. Gives a refined answer about what a gunner is. Develop training, yes. Understand weapon and provide training. Must have 17 years in service. Eby goes on to detail his work in developing weapons systems training, including rifles and automatic fire to clear trenches, enter rooms, near ambush, night attacks. State objects to the expansive answers. Again, McGlynn says overruled. So I think that's like 4 or 5 objections from the state, and they didn't get any in. Plaintiff's counsel continues. What about burst? Yes. Give more detail about differences between semi-automatic and one round versus auto fire. Eby says he doesn't really differentiate between burst and auto. He explains military doctrine to form opinion for a baseline. So military doctrine is there to kind of put out the guidelines as such so that you can form opinions and a baseline. He goes on to talk about being tasked to write urban warfare doctrine, for example. Many different doctrine for different environments and different weapon systems. Doctrine created to shape our thoughts as baseline on how to solve a problem, he said. Eby was in charge of small weapons courses, also oversaw combat marksmanship courses, gives detail about the program. Eby discusses about fire from marksmanship program, but is taught with combat publications like Urban Warfare. He discusses knowledge and work with Michael Mussman, says that he can't share too many stories because they could be illegal, he says, jokingly. The state objects, saying that expert testifying about another expert. McGlynn then overrules, says it's important for veracity of the joint report. Eby discusses combat experience beginning in 1991 Desert Storm, again in 2003, 4, and 5. Describes the difference between the M4 and the M16, from barrel length being the main difference for velocity of bullets. The downside, transport. Doesn't fit all shooters, he said. Eby says such firearms were not semi-automatic only. Counsel asks what primary purpose of the rifleman in combat. Eby explains that they're able to find and suppress enemy, many means to destroy the enemy by air, tanks, hand delivery of explosives. Look for another way to end the fight without more exposure. It's common to carry at least 4 grenades, Eby said. He discusses the rules of engagement. An initial report that he filed was also discussed. And formed the opinion that only 2 firearms that Illinois restricts would be suitable for military. So again, Eby's testimony is 2 of the rifles that Illinois restricts would be suitable for the military, meaning all the other ones, right, more than 170 different rifles, all the other ones he essentially lays out would not be suitable for the military. So he says the M38 and the Barrett M107 are 2 rifles that Illinois bans that Eby says would be suitable for military. 3 rifles, actually. 2 R50 caliber scoped rifles used to stop vehicles. The other's a .308 select fire. The judge asks for slower responses. 3 rifles. Are they general use? No, they're for specific use. And then they talk about the numbers of Marines, 175,000. Only 300 are in service of these select firearms. The M38 never owned by Marines during his time, Eby said. Counsel brings up Exhibit 191. That's the public act signed by Governor J.B. Pritzker, the Protect Illinois Communities Act. Eby again says he evaluated weapons listed and whether they are for military, focused on features, list, and definitions of assault weapon. Asked to read semi-automatic rifle to accept detachable magazine. Eby says no issued rifle is only semi-automatic that he's aware of in the military. To list off name of semi-automatic rifles, Eby says no semi-automatic rifles are issued to general forces, except to maybe snipers, he says. Discusses bilateral forces relationships, comparing firearms, says Turks had some bolt-action rifles, jokingly says no ammo. Majority had select fire systems. Counsel brings up Exhibit 5, H&K Select Fire Document for Military Infantry Review. Focuses on selector switch for safe, semi-auto, and ambidextrous. So those are just some of the things they discussed. This rifle is used by USMC in Afghanistan, then expanded to entire combat force. Explains that the M4 was ordered until 2011. It was replaced with the M27, has an 18-inch barrel. A lot of technical specifications discussed during this trial. Eby said M16 came in 1964, fully in 1968. Then the M4 ordered in 1957. Before that, the M1 Grand was used. The M14 was select fire. The M1 Grand was semi-automatic, but that was in 1957, he says. Currently, majority of Army has M4. Others get X7, which is select fire with full auto, no bursts. Newly adopted X7 has safe, semi, and fully automatic. M4 has select fire with burst but no full auto. Eby continues to discuss other weapon systems, use of burst and full auto in Iraqi battles with rules of engagement, no commands, immediate action upon contact. So back to Exhibit 1, the initial report that Eby put together. They point to page 5, points to 2 studies of Project Salvo. Eby explains Flatchet, and he spelled it. It's a single projection with 3 darts, used to spread shots for accidental hits on a hidden target. Exhibit 20 was then raised. It's the Salvo 1 rifle experiment. Asked why relevant to the issue at hand. He says that groups of shots increased hits on unseen enemy as well as psychological deterrent to the enemy. Eby said he wanted more precision for rifles, but back to Eby's report, he evaluates studies from the 50s and the 60s that says semi-automatic only is not good for combat. Select fire needed for emergencies with smaller caliber, more hits, he said. Court then recessed for a short break. So we're still on day one of the trial, right? Here we are looking at just about 30 minutes. But back on the record, questions to Eby continue. Back to reports and opinion of the semi-automatic only not being sufficient for the military, Eby said, and Eby was a plaintiff's witness. Discussing small arms weapon systems as an experiment meant for configuration of design and best outcome for hits on the target. The Colt AR design was best that could fire full auto with successful accuracy, mobility, subjective user outcomes. So Exhibit 3 was then presented. This was a SAWS report. I forget what SAWS stood for. Again, this is just a rough transcript of all the things that were being talked about during the trial. The document referred to automatic fire. Skimming over the document, the judge directs to focus on Eby's report. So McGlynn says we need to focus on Eby's report. Eby says all reports he reviewed for his evaluation indicate that auto fire in military context leads to more hits. He says he's not aware of any reports that contradict that. Eby was then asked about Exhibit 4 to support statements of aimed fire versus volume fire in offensive and defensive actions. Exhibit 13 is then presented. A military report on hand weapons. Eby said it's another report backing statements that volume hits more targets and has a psychological impact on the enemy. He says he's not aware of any report contradicting that. Exhibit 6 presented. Eby's rebuttal report cites research study that auto-fire rifles are more psychological impact than semi-automatic rifles in the military. So again, they're really hammering home the difference between full auto, burst auto in the military, and semi-automatic only rifles civilians have, and says that no report says that you should have semi-automatic only in the military. Similar to Exhibit 12, any military materials call for elimination of auto fire from military. Eby says no. Asked if training on single-person missions, no. Says single-person missions with semi-automatic only would be a suicide mission. No further questions from the plaintiffs. Then the state gets up for cross-examination. State as defense asked about 4 different combat missions Eby had in Iraq over time. 15 months of combat, fought in Fallujah, second battle. Weapon carried was the M4 rifle. Was it semi-automatic? Yes, but it had burst. Joined in 1982, the M1 had select fire, the M16 A2 had burst, not full auto. Wells directs to Eby's report. Eby says even burst in full auto just takes more trigger pulls. Exhibit 278 presented, article by Eby from October 2004, focused on a sentence of replacement of rifles and fiction of full auto, was a quote out of that report, about having burst. Wells questions training on the M16A2, which didn't have full auto. Auto is less accurate than semi-automatic firearms, says it takes training to fire full auto accurately. Over fire in Iraq created animosity of Iraqi people. So if you have full auto and you're just going nuts, and then you damage a mosque or kill an innocent person behind, it grew animosity amongst the Iraqi people, they said. Full auto standard was limited in use at that time. So they did, the defense came back and said, well, they did limit full auto and the burst auto and such. And Eby seemed to indicate, that seemed to happen in Iraq. Wells says troops using semi-automatic, mostly in recent conflicts, says full auto still necessary in hypothetical future war. According to Eby, Eby says knows of no Army publication asserting otherwise. Says it's critical to have in military, Eby said. Another statement presented, Exhibit 261, a marksmanship report from 2008 presented that says rapid semi-automatic fire, most important technique. Eby says he sees no reference to support that statement. Eby presented that the report is for military. Eby says such reports for small group marksmanship. Wells says Eby presented reports were from before 2008. The report updated again in 2011. Eby says such report is an opinion, wrong and dangerous to eliminate full auto for rapid semi-automatic, and says they eliminated rapid semi-automatic report in 2016. Another field manual replaced that. Exhibit 264 was then presented by the defense. The documents from May of 2016. Eby retired before then. The report says auto or burst fire drastically reduces accuracy because of recoil. Eby disagrees. Wells, then the state's defense here, presented Exhibit 269, H&K M27 manual, the 5.56 NATO ammo presented earlier. Focuses on rate of fire section, cyclic rate of 700 to 900 rounds per minute. Eby says that would melt the rifle. Sustained rate of 36, listed by manufacturer, would not be recommended. Would make it too hot. It could break, even in semi-automatic, 45. And auto, 90 rounds per minute, still too hot and require magazine change. The state as defense focuses on HK semi-auto version document. It says is well suited for law enforcement and patrol carbine. Discusses M855 ammo. Eby has tested that, he said. Discusses optics tested for military capabilities. Wells discusses Eby testing ammo and optics with civilian firearms that were not military spec. Eby confirms, but discusses barrel length impacted velocity. Then the state says military chooses bullets without self-defense in mind. Eby says they determine what can pierce helmets and expand, shoot through barriers, car doors, walls, etc. Wells, the state's attorney here, says that civilian homeowners have concerns of overpenetration. Eby agrees and wouldn't recommend for home defense unless it's the only choice. Wells asks, what about BMG? What's it stand for? Eby didn't know, but from the gallery, somebody sitting right behind me, somebody says Browning machine gun. So some of the people watching behind definitely were tuned in and watching as closely as I was. Wells discusses difference between pistols and rifle bullet velocity. Pistol not sufficient for piercing body armor, Eby confirms. Longer range, pistol not sufficient. Discusses concealed carry. Eby carries pistol with 10 rounds, Glock G42. Other magazines discussed to carry as spares. Eby said most civilian incidents never get past 12 rounds. No further questions from the state. Plaintiffs return for questions for redirect. Asks about the importance of full auto. Eby says it's needed for overwhelming opponents in military context. Says it's critical. Differentiates between marksmanship publication and other publications, with Eby discussing publications, and then the state objects again. So I think this is like 5 or 6 different times that the state objected to Eby's testimony and Pulaski's testimony on day 1, but more discussion on crafting the publication. Plaintiffs then direct questions to the state's focus of the HK semi-automatic only. Eby says that would be good for military because it does not have select fire. Focuses on that would not be good. It might be, that would not be good for military because it does not have select fire. So again, these are just rough, quick transcripts from me using X on my phone to get this out to people. They're not going to have the full reviewed transcript from the court until sometime in December. If it were easier to carry more, he would, as far as magazines. No further questions. Then the state gets back up there. They ask for preferred style of defense weapon. Eby says AR style is most efficient. Says auto fire would end conflict quicker. Says if SWAT can have full auto, Eby said he should, as he is his own first responder. Then the Barnett's plaintiff's attorney returns to question. They questioned about warfare. Eby says it's chaotic and manuals aren't carried when focused on keeping men alive in the trenches. He says firearms not chosen, they are assigned. None are semi-automatic only. Eby goes on to say that some rules of engagement put men in harm's way. Says that he would have told men to use semi-auto in certain times, full auto in other times. Then the state gets back up there and says rules of engagement are important. If not followed, you can be court-martialed. Eby says if you survive. Judge McGlynn then gets his questions in for Eby. They discuss the protocol for different environments to rehearse in and all of that so they can have immediate action when they get into certain things, like immediate reaction. If you know that somebody behind you is going to be shooting, you want to stay down. If you know your men are going to be walking to the left, you want to make sure you aim right, and so on, that type of thing. Judge McGlynn, asking those questions, says, in live fire scenarios, instincts must have immediate action. Yes. Eby gives examples of people taking a knee when someone fires from behind rather than standing and moving left. As master gunner, any training for ambush? Yes. Always rehearsed. Standard mags, 30? Yes. Does military training, warfare experience influence you in your home invasion scenarios? Yes. What weapon system would be best to reload, etc.? McGlynn asks about home defense. Eby says shotgun must be trained with. Says that the pistol also it's poor for home defense. Eby went on to say that the AR is best for home defense for ease of aim. The plaintiffs return for questions as Eby reiterated the AR is important for home self-defense. Eby lives in Missouri. He drove to East St. Louis. He said he hopes my wheels are still there when I leave. Eby told no exemption for retired military like himself. He's aware of that. Then the questioning concludes. Set for recess. They return, and so on. So again, that's just day 1 of the gun ban trial there. Something that obviously there's a lot of things to be said about just day 1 of that trial. So let's take a look at day 2 as we get into the next day here of the gun ban trial. Day 2 of Barnett, Second Amendment challenge to Illinois gun and magazine ban, court in session. Day 2 of the bench trial, litigants identify themselves, and the plaintiffs called James Ronkainen to testify. This was a lot. He was the only one to testify on day 2. So Ronkainen discusses first time he fired a firearm at a young age, grew up around shooting sports. Plaintiff's attorney presents Ronkainen's CV. It's his resume. Education, mechanical engineering, employed by DuPont out of school, worked with DuPont subsidiary Remington for nearly 40 years. Gives a history of the company. He worked on Model 1187, semi-automatic shotgun developed in the 1960s. Ronkainen says that firearm is versatile with different shells. He also worked with the Energy Development Lab for color printers. In 1990, Ronkainen was a senior research engineer for Remington. Has children that are active shooters and shooter sports. Discusses Model 700 bolt action rifle. Says the variants have been adopted by military for sniper weapon systems. The Marines have the M40, a modified system for sighting systems, a Model 70 at heart, he says. Then he discusses Remington standalone facility brought about in about 1990s. Spent most career in Kentucky, work done on Model 700 firing mechanism. Wanted to develop system fired by electronics. Approached by the military about that. In that time period, acquisitions were taking place in growth phase of the company for Remington. He discussed some competitors. By 2008, Ronkainen promoted to direct DoD law enforcement product development. He discusses X-Mark Pro trigger development for better control of trigger mechanisms. Worked on several semi-automatic trigger assemblies. Led teams for military and law enforcement programs for sniper weapon systems. Worked on the M4 replacement. Ronkainen talks about creating the Remington Adaptive Combat Rifle. Discussing the Bushmaster collaboration for modern sporting rifles. Again, a term they used a lot. Modern sporting rifles is a term that was used a lot in day two. Anyways, they talk about Bushmaster being a sister company of Remington. Ronkainen discusses modular sniper rifle development, gas piston operating system, and benefits of new system to refine gas of debris. The RGP was full auto, requirement of a solicitation from the military. Discusses the difference of the firing mechanisms for semi-automatic and full auto. One pull per round for semi-automatic. Full auto uses the gas and continues to fire with one pull. Discusses the internal components, the pocketing of the trigger groups, two different systems, he says. They're two markedly different systems. Ronkainen then continues to discuss the difference in hammer and selector for full auto and semi. Both are totally different builds, he says. More on Ronkainen's resume. They pulled that up quite a bit. Defense procurement machine system made modern sporting rifles, they said. Never made bolt or lever or pump action. Modern sporting is AR-15 and other similar firearms, all semi-automatic. DPMS came under control of Remington brand, says federal license required for manufacturers. Ronkainen discusses AAC, the product line of silencers, suppressors, 300 blackout ammo, and related firearms. In 2011, became director of engineering for a team of Advanced Armament Corporation, AAC, working with federal LEO procurements, maintained oversight of military product, assumed responsibility for a modern sporting rifle at Remington, Bushmaster, and DPMS. Continuing on here, again, thanks for hanging out. It is Bishop on Air. I wanted to remind you guys to go over to America's Talking Network and get that live show each morning. All right. This is me on my own time, Bishop on Air on a Sunday stream, and I'm just going through the 4 days worth of the transcript from being inside the courtroom for the gun and magazine ban that wrapped up Thursday. So I know some of you aren't going to read all these tweets, but maybe you want to put this on the background while you're getting ready for work or whatever the case may be. So hopefully this is beneficial, because they won't release the official transcripts from the court until sometime in December, which is 2 months, 3 months away. All right, so back to day two. The plaintiffs asking Ronkainen, the plaintiff's witness, former Remington director, about a variety of things. So, maintain oversight of military product, assume responsibility for all modern sporting rifles at Remington, Bushmaster, and DPMS. Ronkainen says Remington competed for military contracts in other agencies like Secret Service, Homeland Security, IRS, ATF, FBI, and even foreign militaries like the Philippine Army. He discusses Remington R4, their version of the full auto M4, says no military ever asked for semi-automatic only. It was always full auto. So military was not asking for semi-automatic only rifles. This is a point that was brought up even with the Eby testimony, right? Never saw semi-automatic only rifles in the military. You got Ronkainen, who helped develop firearms and rifles for military use, and says that never did they have a military come in and say that they wanted semi-automatic only. It was always full auto. Then they discuss the rigorous process of manufacturing military spec firearms. Ronkainen says Bushmaster and DPMS never met military spec needs. Says that the battle rifle must be full auto built. That's different from civilian rifles. He talked about how it works against accidental discharge. If you pull the trigger, you intend to pull the trigger. They discussed accuracy requirements for such rifles. The spec requirements for military spec are 60 to 70 pages long, he said. Ronkainen discusses business with the U.S. ally, the Philippines, who were looking for replacing an aging firearm. R4, full auto provided, discusses accuracy needs for life of barrel, says military-grade rifles must be compatible with military spec ammo. Caliber offering was 5.56, 3.38, 300 Win Mag. For MSR, modern sporting rifle, it was 5.56. Sniper systems were bolt action for precision. Discusses difference between bolt action and other firing systems. Ronkainen discusses various gas-powered firing mechanisms to explain difference from bolt action. Says bolt and semi-automatic only fire one round when the trigger's pulled. Says Remington never considered selling semi-automatic only to the Philippines. Totally different from full auto. Says the auto sear pin is different for full auto and semi. Heat treatment, accurate drilling, not something the average Joe can do in a garage, he said. Requires detailed equipment, mechanist, etc. Machinist. Ronkainen doesn't think average Joe can take an AR-15 and make it full auto. Ronkainen says cuts require machinery the public doesn't have access to. Then they take his resume back up and they look at all the different hats at Remington, overseeing engineers at multiple locations. Says Remington separated military and civilian manufacturing with separate locations and security. Says separate locations also because of the different manufacturing needs for commercial modern sporting rifles and military machine guns. Ronkainen questioning continues, discussing separate testing for MSR, modern sporting rifles, and military spec firearms. Judge McGlynn then called for a break. Back after that break, more direct examination of the witness, James Ronkainen. During the break, plaintiffs brought in 10 boxes of evidence, questioning back to the testing facilities and separates for commercial and military spec. He says that hundreds of millions of rounds were tested. The gallery is the only place that ammo and firearms come together with the test jacks and the brass catchers and other implements. First, high-pressure proof rounds fired remotely. After that, more rounds, and then the tester confirms there's no malfunction. Then taken to accuracy on the range at 100 yards. If issues are found in accuracy, more are tested. Ronkainen would never allow live fire discharge by worker of a gun that was tinkered with in a garage, he said. Tinkered with the sear. He says that he'd never fire such a gun modified to shoot full auto. It's illegal, and questions if done properly, it's just not safe. Ronkainen discusses definition of the modern sporting rifle, says MSRs he's been involved with have some other features shared across types, from detachable magazines, barrel shrouds, pistol grips, telescoping stock, etc. Back to his resume in 2016, Remington was consolidated with manufacturing facilities to Alabama. For civilian MSR production, Ronkainen's team developed new MSR platforms and subsystems like DPMS Gen 2, MSR platform capable of shooting compact ammo platforms, two-stage trigger system developed to provide more uniform assembly among groups, able to put large cartridge into some systems. AR-15 and AR-10 platform is modular, able to work on gas systems. New carbon fiber handguard systems for lighter unit. Advancements intended to enhance civilian usefulness for array of circumstances and ergonomics. Ronkainen discusses ergonomics meant for safe use. Discharge of bullet pressure discussed. He says that it's a pressure containment device, mechanical device, must fit user for better performance. Back to the resume, holds 9 patents, co-inventor on others, spent most professional life with one of the largest firearms manufacturers in the world, demand increased for lawful MSR products, objection from the state. So Ronkainen is still being questioned by the plaintiffs. The state objects to that line of questioning. Ronkainen doesn't have such data, they said. McGlynn notes the objection. He didn't overrule it. He didn't sustain it. He just notes the objection. Then the questions continued of Ronkainen from the plaintiffs. Ronkainen tracked trends from demand of different MSR platforms. Remington invested millions in development, testing advancements because of increased demand. Ronkainen says Gen 2 took a lot of time and manpower. DPMS focused solely on modern sporting rifles, he says. He says that sale for hunting, target competition, home defense, questions about training for 3-gun competition gives participants confidence to use for self-defense. Somebody objects from the state. State argues he's not an expert on that. McGlynn says that's out of scope. Then the plaintiffs try to give foundation. State argues Ronkainen not here for that conversation about self-defense. Plaintiff's attorney says training on targets to train for self-defense, not a novel concept. Ronkainen says he's been to SHOT Show convention, takes consumer input to the design shop. Otherwise, it's a shot in the dark, he said. Consumer input weighs a lot. They build rifles for target shooting with MSRs. Discusses different amounts, different types of ammo tested, 300 Blackout, 204 Ruger, and others for new caliber offerings. They have different ballistics. Ronkainen then discusses modifications to the AR-10 to take different ammo. These developments design team engaged in for customizations for small and big game hunting with an AR platform to suit the customer's needs. Ronkainen discusses the 450 Bushmaster cartridge difference for hunting, all examples of innovation to meet surging demand, including home and self-defense. Ronkainen says innovations weren't just for ammo, but handguards and other system components to fit needs. If product doesn't perform, word gets around and won't sell. He says that they deconstructed competitors' products to find new subsystems, trigger groups, controls of safe selectors, etc. Discusses ambidextrous feature limitations for military and was only developed for customers. So if you're a left-handed shooter and you're in the military, you got to learn how to shoot right-handed, apparently, because they don't make ambidextrous. They don't make ambidextrous firearms for the military. Goes on to say a substantial undertaking to change firearm for left-handed capability. Says at Remington it was a desire, but competition had it for MSRs, only 10 to 15% of the population. Ronkainen says Remington did make other left-handed models for bolt action as an example. Says ergonomics of right hand and left hand importance for sight clearance when cartridge is ejected. Says AR platforms, modular in nature, very good to make way for left-handed design. Ronkainen discusses enhancements for design for safety of user. Focuses on design of M16 as select fire weapon. Ronkainen says before NFA, consumers could possess. After, tax stamp needed for possessing. Remington brand AR-15 was the R-15, different stocks, customizable. R-25 was Remington's version of the AR-10 with larger cartridge, not designed for military use. Never had military ask for such. Bushmaster XM15 is not designed for military use. Military never requested. DPMS utilized cat names, Panther, Kitty Cat as examples. All DPMS for civilian, not military. Never had military ask for off-the-shelf DPMS for military use. Ronkainen focuses back on military demand. Never asked for 22 long rifle caliber rifles. Says AR-15 manufactured differently than the military spec. Different testing, materials, performance. Are AR-15s identical copies of military rifles? No. Modifications? State objects then. McGlynn overrules that objection. Discusses the bump stock. Sausage. That's a errant word. Still one trigger pull per fire. Says military never asked for off-shelf AR-15 with bump stocks or trigger cranks or to use any AR-15 in a war zone. I think that's interesting. All right, so he says explicitly, the military never asked for off-the-shelf AR-15s with bump stocks or trigger cranks or to use any AR-15 in a war zone. Again, looking back at what Eby said, very similar, right? Military contractors didn't come and say, we want that semi-automatic only rifle. You know, the one that the civilians can buy. No, they wanted burst or full auto. So, says military spec requires different materials for different conditions. Ronkainen explains different testing accuracy requirements for mil spec versus modern sporting rifles. Says knowledge from military developments was utilized in developing some modern sporting rifles, and then they discuss the specific metal treatments for barrels. He spells some word for a process. I couldn't even do it as he spelled it real fast, but the judge praised him. All the litigants and people in the gallery praised him. It was some kind of metallurgy type of thing that he spelled out. But anyways, he discusses nickel boron treatment for plating on bolt carrier groups to increase time of cleaning and ease of gunk cleaning. Some features useful for self-defense. He knew customers wanted such firearms for self-defense, and the judge called calls for a 5-minute break. Back on record. Another 15 minutes before lunch, Ronkainen discusses enhancements of civilian MSRs. If applied to MSR, he says that it would not be suitable for military-grade weapons. Says at Remington, feedback provided by military for Remington military spec productions and specified options taken into account. Military-grade weapons stayed segregated from MSRs, Ronkainen said. Military wouldn't take late deliverables. Consumer demand would be more flexible. Discusses all the other things military demands be delivered, like documentation, technical specifications, and anything else that's responsive. Ronkainen discusses first article testing, a required test in front of government entities in early production of products. Says the military guns Remington built were all select fire. None were modern sporting rifles. Then it was time for lunch break. So after that, case against Illinois' gun ban continues. Direct examination of Jim Ronkainen continues. Plaintiff's attorney brings up materials on the product catalogs. Exhibit 102 through 120 introduced, admitted without objection. All the other exhibits brought forward. Advanced armament catalog. Exhibit 103 shows AAC MSR with suppressors and 30-round magazine. Exhibit 110 is Bushmaster catalog listing different models of rifles. Exhibit 119 is a Remington catalog from 2012, the 50th anniversary of Model 700. Shows an AR-10 style firearm, focuses on Remington Versamax shotguns. Versamax Tactical holds 8 with an extension. Not allowed in Illinois. Semi-auto shotgun suitable for whatever purpose, they said. Then they discussed the thumbhole stock of Model 1187 semi-automatic shotgun. Exhibit 115, Remington's catalog from 2013, shows Versamax Sportsman. Black composite versus camo. Makes no difference to function, he said. Exhibit 118, Remington's 2014 catalog showing new pistol introduced that year, focuses on Versamax competition with extended magazine tube. Again, no extension magazine tube for shotguns allowed in Illinois. Ronkainen discusses how to limit shotgun magazine with a plug to comply with certain hunting regulations, and users can use Versamax for both hunting and competition. The differences between models are superficial, he said. Then they show Exhibit 80 through 100 with different gun digests for each several year, entered without objection. So Gun Digest is a gun yearbook, Ronkainen said, showing the type, suggested prices, etc. Exhibit 90 is 2012's Gun Digest. Scrolling through the hundreds of pages there, look at descriptions or of some of, but not all, the features of firearms during tenure at time of Remington. Price of modern sporting rifles stayed robust. They discussed the ATF report, and this is interesting, an ATF report about produced firearms. And for any given year, the review of the data of those firearms that are manufactured. So if you've been watching this live, a few drops here and there, but again, we re-upload these segments, so be sure to come back to Bishop on Air and you'll be able to find this entire segment and you'll be able to go through. We're going about an hour right now of this recorded content, so I appreciate you guys sticking through in the live stream. But again, you can always come back to and watch this as well after the fact, because we just got through lunch of day 2 out of 4. So market was growing, Ronkainen said, 2007 to 2017. ATF production report submitted as evidence without objection. Now this is interesting. The report used to analyze where the market is and where it's going. In 2013, there were more than 80 modern sporting rifle manufacturers, Ronkainen said. Other manufacturers also saw sales expansion. Then they say objection. So the state's objecting. Pure anecdote, they say. McGlynn asks if Ronkainen was like on a board or like the VP. They said he was just a director. So McGlynn overrules. Then the question comes up again. What about other manufacturers? 80 different manufacturers of modern sporting rifles? Objection. They objected again. Undisclosed. Plaintiffs say it's in line with the expert's testimony. It's not an opinion. The state says in deposition that's a question and answer period that they have before they go to trial. In his deposition, he was asked about analysis and only gave rudimentary review. Now it's being introduced at prejudice of the state said. Plaintiffs asking about experience. State says he's a rebuttal witness. Plaintiff said state had a chance to respond and didn't. State says he could have filed additional reports and did not. McGlynn reserves his ruling. So he didn't overrule, he didn't sustain. But back to the question about 1.1 modern sporting rifles produced, Ronkainen was asked. He confirms. His report displayed in 2012 for Bushmaster is NA, not available that year, including in Remington's totals. So they didn't have Bushmaster totals in 2012 for this ATF manufactured report. It was instead in Remington's totals. Volumes that year similar to DPMS. State objects, says number review is just anecdotes. McGlynn says he'll review the deposition. Plaintiffs say records from the government. The state says they don't show Bushmaster. Questions continue. In 2012, 212,920 rifles produced by DPMS. Estimates similar numbers as Bushmaster. Bushmaster moved locations and FFL changed to Remington. They did make MSRs during that time under Remington. In the chart for DPMS 2015, smaller number is 50,475. Production was shifting to different location. In 2014, DPMS manufactured 79,118 rifles. The Gen 2 product was in process of production, shifting resources. Exhibit 70 displayed. This is the 2013 AFMR data from ATF. And then it talks about pistols, revolvers, and rifles, and differentiates caliber, including frames and receivers sold. In rifles category for 2013, DPMS, go to the state of Minnesota, shows Remington arms with 212,920. These are manufactured numbers. That was DPMS, Ronkainen says. In 2013, 80 plus were MSR exclusive manufacturers, meaning they didn't make bolt action. They didn't make revolvers. They only made modern sporting rifles, like an AR platform rifle. The state says that was not disclosed, so they're trying to object. McGlynn overrules. It's just counting up publicly available data. If one rifle made, must report. Palmetto State was a competitor. AFMR data will show how many they produced. Remington invested millions of dollars in MSRs over years, investing in tooling, real estate, hiring engineers, research and development, equipment, materials, ammo, computers, manpower to build, and such. Did they actively invest to meet the growing customer demand? Yes. No further questions from the plaintiffs. So they took another break. Goes on, back at it, ready for cross-examination from the state. Focuses on ATF and AFMR data. So you've got the state doing their cross-examination. Modern sporting rifle, no data compiled by ATF. Doesn't state what is civilian or law enforcement officer. But Ronkainen said, can't all be law enforcement officers, as they would have no room in their vehicle for police. So this AFMR data from ATF, right? So the manufactured data. Ronkainen's going through and saying DPMS only manufactured modern sporting rifles. There's their number. All right, tens of thousands. Bushmaster only made modern sporting rifles. There's the number, tens of thousands. Adds all these up, and his knowledge of all the companies that made modern sporting rifles, adds those up. That's the number that he gets. Hundreds of thousands of rifles being made that are only semi-automatic AR-15 type rifles. So I think that's what the exercise was there. But back at it for cross-examination, Ronkainen says they can't all be bought by law enforcement. The AFMR data only dealing with manufacturing, not who's buying what. But the state seems to try to want to say, well, it could be civilians buying these or law enforcement officers. And again, Ronkainen says there's no room for all these firearms in police vehicles if it was only police buying these. ATF data isn't about who purchased, just manufacturing. It's not a purchase type database. State asks about Ronkainen's report showing production volumes from DPMS and Bushmaster. The report includes no total MSR production by all. Report doesn't include size of markets when he left Remington in 2016. Ronkainen says trends were up overall for production. Growth in the market after 2004 federal ban lapsed, he acknowledged. More recently, market has accelerated further since 2016. Not all semi-automatics are MSRs, correct? Correct. MSR, an AR platform, as AK and SKS. AR, originally designed for military in the 50s, as were AK for Russians in the 40s. Specs and standards for military include some aspect for commercial MSRs, Ronkainen said. They have to meet requirements, but not to the level for the military. Military is very explicit about what they want, pressure ranges, acceptable testing, etc. There are standards that are shared from MSR and military, but military overall exceeds MSR standards. MSR are high accuracy, possibly more than military with lighter trigger pull weight. Higher military specs to ensure no unintentional discharge. Shooter firing 30-round magazines with 3 pounds of pull is at 90 pounds. Again, this is the state, all right? This is the state asking questions of Ronkainen. So you had the plaintiffs ask their questions. The state comes in and asks their cross-examination. This was interesting because the state, they started this line of questioning about the pounds per square inch of the trigger pull, and the difference between the trigger pull for modern sporting rifles and military firearms. And they said that it could be, military firearms could have 8 pounds per square inch, while a modern sporting rifle could have 2.5 to 3 pounds per square inch. And earlier in testimony, Ronkainen said some of these specifications were to ensure that you didn't have discharge of the firearm improperly in the military. So anyways, state asks, shooter firing 30-round magazine with 3 pounds pull, 90 pounds? Requires same trigger pull for each individual pull, Ronkainen says. So it's 3 pounds per pull. It's not 3 pounds and then compounded, it's 6 pounds and then compounded. No. So the state says 90 pounds. And then there's an objection. The plaintiffs say that's just wrong. The state says they're looking for whether there'll be fatigue. Ronkainen says it doesn't matter. So it looks like this is, they were trying to say, well, you get more fatigue if you fire a military firearm because it's, 6 to 8 pounds per square inch or something to pull the trigger, where you don't get as fatigued if you fire civilian fire. But Ronkainen said that doesn't matter when it comes to fatigue. So that was an interesting moment in the courtroom where even some in the gallery were somewhat scratching their head as to what exactly the state was trying to get at, saying that cumulative, you've got 3 pounds per square inch trigger pull. If you got a 30-round magazine, it makes it 90 pounds. Anyways, state continues cross-examination of Ronkainen about separate manufacturing for civilian and military production. Some equipment could be shared, but would need special control, not just left in the open. Testing area questioned, not exclusive to military. Ronkainen says yes. Testers would be different. Improvements question, they can be tried with commercial, but can't innovate with military. Have to adhere to military requests for military. Ronkainen said military innovations found its way back to commercial MSRs. Civilian gun owners will make aftermarket improvements, not done with military. Bump stocks, not used in the military. Can you attach to an AR-15? Yes. Most flow of innovation from military platform into civilian platform. Any innovation you wouldn't do. Select fire is prohibited, Ronkainen said. Demand, costs would be what drives military innovations to civilians. Pistol grips for military, yes. Telescoping stocks, yes. Grenade launcher, not from Remington. Barrel shroud and handguard, yes. Detachable magazine, yes. So the state seems to be going through and saying that a lot of these features that are banned by the states are used in the military. In 2013, modern sporting rifle grouped with military and law enforcement officer design. Ronkainen tells the state that he was not in the sales department or marketing. He was an engineer working with other departments as teams for military and civilian firearms. Conversion question, drilling into the receiver only. Maybe other ways, not aware of people who drill holes into the receiver. Not only change needed, other changes are needed, other milling is needed, Ronkainen said. And they're talking about modifying the lower receiver. Not anywhere or anyone doing that personally, he knows. His report was a rebuttal reports included with somebody else. Exhibit 205 displayed by state. Objection filed by the plaintiffs. That's overruled. So a couple of different objections from the plaintiffs overruled as well. Discusses the English survey rebuttal and NSF publications. They only discussed that briefly, the English survey and NSSF publications. Washington Post Ipsos survey not reviewed. Ronkainen was not reviewing that. Or rebutting that. Rebuttal also of Lucy Allen. Objection outside of scope. Withdrawn. Rifles used for self-defense. Didn't object to that, Ronkainen said. Can you show me? State redirects. Did you review database of self-defense? Only rebutting report, shown in rebuttal, says that he rebutted opinion based on personal experience. Then they discuss about ammo for ethical hunting, discusses caliber and range with .223 and .556 to ethically harvest deer with one shot, wants clear shots to keep meat and pelt intact. State asks Ronkainen about Remington's size of one of the largest manufacturers. Wasn't producing MSRs during certain period up to 2007. The state then brings up Remington's previous bankruptcies. Ronkainen's associated with the National Shooting Sports Foundation, they said, has firearms manufacturers as clients for his new business. Up to 80% of the income, the state said, was from such businesses. Product design slowing, but litigation assistance picking up. The state then puts his income at $350,000. Then it's a recess. Back in session, redirect of Ronkainen. Nothing further, plaintiffs say. No further witnesses today. So we actually got out of court on Tuesday. Again, that was day 2. We got out a little bit earlier on Tuesday, so that was pleasant, I will say. But let's go and find where we at. Day 3 of the gun ban trial. Now, again, a long video here. We're about an hour and 10 minutes of this recording, and we're doing each day of the 4-day trial. The rough transcript, all right? The rough transcript to get that out to you guys in a different format. Right now, it's on my X page. You can go through and see all the posts there. Me sitting in the courtroom, feverishly going on my phone, just listening with my head down, barely looking up to see exhibits. But I wanted to give this to you in a different format as well. So you can go back and listen to it if you want. I know it's probably monotone. And if you look at, obviously, the rapid, the text that I was sending out through X, it's not, all spelled properly and whatnot, truncated. We're not going to get the full transcript of the 4-day trial until mid-December from the courts. They're able to go through and review it and to, say, oh, we want to change this here and change that there. But we're not going to actually get that released, I think, until mid-December. So I wanted to get this out to you guys in a different format so you have it. So let's get back to it, if my voice will stay with us here. All right, so Illinois Gun Ban Trial 3, Day 3. East St. Louis, here we go. Stephen Randall Watt, called by plaintiffs. Goes by Randy, designated as expert witness for plaintiffs. Issued report. Exhibit 24 was shown. He was in law enforcement for 36 years in Utah. He was a patrolman, a detective, assistant chief, and chief. Also was on SWAT. As a commander, he directed training, wrote standard operating procedures, etc. Watt says training included rifles, carbine, .223, .556, general service patrol rifle used as well. Across the span of his career, he trained regularly 4 times a year for patrol. SWAT trained monthly with live fire. Watt also served in the military, raised to rank of staff sergeant over several years, retired as colonel. Says firearms changed over the years, but used M4 for majority of military career. Says no military issued rifles were semi-automatic only. They were all select fire. Again, this is the second witness that the third witness that said no military, wanted semi-automatic only. That they hammered that home several times. I think that's directly to answer to the 7th Circuit U.S. Court of Appeals. They were all select fire in the military. In his time with Utah National Guard, Watt says requirements for his unit had him maintain certification for military weapons, including ones held by enemy military, maintain physical fitness, combat readiness, etc. For weapons training, has to learn all about the parts, the takedown, etc., including those of foreign military. Any training on use of auto fire, the state objects. Says Watt was not presented as such an expert. The plaintiffs say that they are establishing his personal experience. The state says full auto for self-defense is not legal, and in depositions, Watt was not giving such information as a witness. Again, the state objecting to the question, any training on the use of auto fire? McGlynn says objection is premature. And questions continue. Watt says he did receive full auto training. Says it was a basic training skill and continued on, depending on assignment. State again objects. Now, thinking, I'm rereading this for like the first time after posting it, and I'm thinking back to like day 3 and 4. We're on day 3 now, but day 4, there was a lot of conversation with other state witnesses about training on full auto, and their state witnesses said that they didn't train on full auto, former members of the military. So it's interesting to see this again, just, rereading it. But question continues. Watt says he did receive full auto training, says it was a basic training skill, and continued on, depending on the assignment. State objects, says Watt is getting into full auto training details outside of scope. McGlynn says he's not hearing questions about opinion. State says their objections based on discussion of military tactics that was not disclosed, and state witness not prepared to rebut such. Plaintiffs say line of question is still in line. McGlynn overrules the state objection, so it's in the record. Watt discusses overseas mission in Afghanistan where he fired rifles. Hard to say how many times. Could be several times a week, with some weeks not, or 7-hour battles. Fired a bunch of times. Says he fired M4 full auto to mark targets for air defense. Can't say how much he fired. Witnesses other fire full auto in combat with enemy. Gives tactical objection of suppressive fire to fix enemy in place. And then they object again. The state says that that's opinion that has not been disclosed. McGlynn overrules. Watt discusses second deployment to Iraq in 2007. He was there advising senior leadership for counter-terror operations, had to discharge his rifle in Iraq in a red zone, subjected to all conditions of combat and to engage with rockets, snipers, IEDs, and ambushes. He says in firing an M4 in Iraq for combat, he didn't use full auto or witness others use full auto. So that's interesting. He says in firing his M4 in Iraq for combat, he didn't use full auto, or he didn't witness others using full auto. Training in Iraq involved firing M4. Discusses the report where he discusses that he trained foreign forces like Thai Special Forces, Japanese Special Forces, Philippines Rangers, and Canadians. Says never recalls any general service firearm being semi-automatic only. Watt asked about non-military law enforcement firearms training. Handgun, submachine gun courses that he attended included tactics with duty sidearm and submachine guns, alongside other training on MP5 9mm submachine gun, plus popular with law enforcement agencies. Says he never carried MP5 as law enforcement officer as a law enforcement officer. Let me come back over here for just a brief moment as the live stream seems to be blipping on me as I refresh something. We'll see if we can get this back up and running. So we are still recording, which is good. So I'll make sure this gets uploaded entirely. So we are connected back with the live. So Watt, and again, those watching live, if you get kicked off, maybe it's the Sunday evening internet deal. I don't know why, but yeah, this will be uploaded in its entirety so you can come back to it. Watt asked about non-military law enforcement firearms training, handgun, submachine gun courses attended, including tactical, trained on the MP5 9mm submachine gun. In SWAT units would use select fire, discusses other training courses. Watt discusses shooting drills, instruction ratings, etc. Week-long drills include handgun and shotgun training, where several hundred rounds, up to 1,200 with pistol, 1,000 with a shotgun were fired, qualified and requalified as an instructor. Watt talks about drills designed for defensive shooting events, discusses transition to red dot sight training for pistols, discusses other training as a civilian on his own time with Rob Latham, or is it Latham? Watt discusses certification as gun sight range master, was a contract employee with gun sight. Other trainings discussed, explains a carbine is a short, maneuverable rifle with a detachable magazine. Pistol grip, no adjustable stock, discharged rounds with carbine during some training courses. More trainings discussed, including concealed carry training, says training for real-world self-defense purposes, multi-stage trainings, fired hundreds of rounds in training, all trainings found in Exhibit 24. So they really talked about all the different training he had. They talked about a whole host of things. So yeah, people coming in, it must have restarted entirely. We've been going at this for about an hour and 20 minutes for those who are just jumping onto the live stream. I will have this as a standalone video. All right, so a little bit later on tonight, come back to the channel. We'll be able to watch it standalone. So I appreciate you guys coming in and checking this out. But anyways, going through the transcript. All right, we're looking at the transcript from my X account, but some of you might not want to go through X. I'm giving this to you in a totally different format so you can access it here as well, because we're not going to get the transcript from the court until mid-December. So anyways, back to the plaintiff's witness, Watt. Watt was had a company known as SRW Incorporated with broad range of responsibilities, including Warriors Creed for civilian training. That course includes concealed carry, defensive carbine, pistol, shotgun, force-on-force, and tactical training, concealed carry training, including Utah required courses. For defensive carbine course, Watt says, meant for defense of self, home, workplace with carbine rifles. Safety, safe handling, firing effectively, malfunction clearance, etc. Participants bring their own rifles, generally AR platform style. They're always semi-automatic only with tactical magazines, have pistol grips, flash suppressors, but not all of them. Up to most of those features. Says there are California compliant carbines. Watt says AR pistols brought by participants to courses. Says AR pistols accept detachable magazines. Some have flash suppressors and barrel shroud with some rail systems. Participants bring their own magazines. Rare that they are less than 30 rounds. SRW courses are popular with 3 different levels, twice a year, around 16 attendees each. The plaintiff's witness, Watt, says SRW has offered courses since 2008. Then they take a brief recess. Back in session, Watt questioning continues. Says attendees of SRW courses are members of the general public, typically not used for law enforcement officer certification. At gun sites, courses are similar but much more in depth. Says that he taught at gun sites with their carbine courses. Watt discusses more training, says can't put a number on the size of market for other trainings, but it's large and broad. He discusses SHOT Show, largest firearms industry trade show in Las Vegas every January. Says hundreds of thousands of attendees, talks to trainers from all over the country and the world. Plaintiff's attorney focuses on defensive pistol courses, and Watt wants distinction between AR carbine and other pistols. Says participants bring AR pistols to carbine courses. They don't allow AR pistols to defensive pistol courses. Revolvers are not included in pistol courses. Separate courses for revolvers. Watt then says participants bring their own pistols. Some have threaded barrels that allow for compensators to reduce recoil to follow the target for safe and effective use. A basic rule of firearms to use is safely. Again, I think this is another issue that they wanted to make clear, that a lot of these attachments, they're meant for safety. A lot of the compensator meant to reduce recoil so you could safely fire the firearm. Talk about some of the other things as well. But back to it. Watt says participants bring their own pistols. Go on down here. Ubiquitous for 9mm, 15, 17. Some have 20-round magazine capacities. Discusses defensive shotgun courses. Participants bring their own firearms. Courses focus on tactical shotguns, shorter but not short barrel. The defensive shotgun includes semi-automatic shotguns. Watt discusses standard 7-round shotgun tube is common at SRW courses. His company, SRW, popular course, but is facility dependent. So you need steel targets for shotgun. He discusses gun sites shotgun courses. Then they present Exhibit 191. It's the Protect Illinois Communities Act. They focus on Section 24 1.9, assault weapons, and focuses on rifle with detachable magazine. Lists the features like pistol grip, thumbstock hole, collapsible stock, flash suppressor, shroud, etc. Watt says in his opinion, such rifles are commonly possessed. He says, quote, my opinion, these are the most popular in the firearms training and self-defense industry based on his experience across the country. Plaintiffs point to Exhibit 191 section about definition of assault weapon, pistol being a threaded barrel, second pistol grip, shroud, flash suppressor, buffer tube, etc. Watt says AR pistols have such features. In Watt's opinion, such firearms are very common as a self-defense firearm based on his experience. Again, another common use test there. Watt says threaded barrel of a pistol commonly possessed, not rare. Exhibit 191 discusses semi-automatic shotgun with pistol grip, detachable magazine, collapsible stock, grenade launcher, etc. Watt says his opinion, absent grenade launcher, other features are very common. For rifles under definition of assault weapon, they are also very common. Watt says such firearms are very suitable for self-defense. Watt's talking about AR, AK, things with features suitable for self-defense by improving ergonomics, accuracy, control. Says semi-automatic fire, detachable magazines are suitable for self-defense. Not having to hand operate major parts of the firearm so the shooter doesn't have to worry about that and focuses on shooting, again in self-defense situations. Collapsible stock allows for fitting different people, Watt says. Line of questioning objected to by the state as leading. McGlynn says not to lead the witness. Again, I may have dropped a word there. Don't lead the witness. Questions continue. What is importance of stock size? Watt says it allows eye relief to utilize sights. Short people need shorter stocks. Would be difficult to effectively use firearm if it did not fit. Ever the case, fit is not important. Objection. State says it's the leading question. McGlynn overrules. Fit is very important. Watt says pistol grip allows readily placing of hand for control, manages recoil, repositioning. Says he's not aware of AR without pistol grip. Discusses ambidextrous controls, importance of position for dominant hand of shooter for safety switch, and effective control for shooter. Allows left-handed shooters to operate firearm way it should be controlled. Asked if aware of any types of semi-automatic rifles that utilize ambidextrous that are not AR. And Watt says no. Forward grips, aids in reducing and managing recoil, etc. Flash suppressors, suitable for self-defense. Yes. Suppresses muzzle flash to direct away from eyes and direct gas to assist in combating recoil and muzzle rise. Watt says all such features assist shooter in self-defense, including barrel shroud, which ensures shooter can control rifle without being burned. Back to Illinois' definition of assault weapon pistols. Watt says his opinion, the AR pistol with such features is a very suitable firearm for self-defense. Shotguns with such features, Watt believes are suitable for self-defense. Watt says semi-automatic shotguns allow rechamber without shooter changing direction of the barrel, suitable for self-defense. Says detachable magazines for shotguns suitable for self-defense. Fixed magazines with more than 5 rounds are suitable for self-defense. Watt says he owns several AR rifles for self-defense and to train others. Always uses 30-round magazines. Says he owns various AR pistols with features that were discussed. Owns threaded barrel pistols for compensator and suppressors to protect what little hearing he had left. Watt says he owns several semi-automatic shotguns, including some with pistol grips, detachable magazines, fixed tube magazines with more than 5 rounds. Ensures that he doesn't have to reload in unknown self-defense situation. Never know how much ammo you may need in self-defense situation, he said. Watt says he's been involved in military and police combat, been in law enforcement for 36 years, exposed to a lot of officers, asked if officers have used AR on duty for self-defense. State objects. New opinion, they said. Plaintiffs say it's not opinion. They're asking about his personal experience. Overruled, McGlynn says. So he then answers the question. Yes. Questions about differently designed bullets. Another objection. And the state says this is a new opinion. And I think what they mean by that is it's not something that was brought out in a deposition of Watt. So a lot of the objections were either out of scope of what were the focus that they knew Watt was going to do, or they knew other witnesses were going to do, or if it was something that they hadn't already known was going to be discussed in open court through the depositions. So just a little bit of kind of, litigation education here, I guess. But yeah, new opinion. Overruled. Caliber similar, grains and length of bullet can change. Why different bullets for some cartridge? Same objection. Overruled. Caliber similar, grains and length of bullet can change. Why different bullets for same cartridge? Same objection. Overruled. I mean, this is kind of rapid fire, right? Question. Objection. Overruled. Answer. Question. Objection. Overruled. Answered. Question. Objection. Overruled. Answered. Anyways. Let's see here. Same bullets in military as in new law enforcement. No, military designed to penetrate body armor. Over penetrative. Self-defense, you want to limit that. Watt goes on, says he fires AR rifles a few times a month over his life. Cumulative except the military, a couple 100,000 rounds he says he's fired. In military, more than a couple 100,000. Not a lot in full auto, he admits. Says 100,000 AR pistol rounds, non-military. Shotgun rounds shot in lifetime, non-military, tens of thousands. First time shooting was 8 years old, he said. It was a shotgun. He shot revolvers, bolt action, lever, etc. Not a year goes by, he doesn't shoot. Watt says he chooses firearms for self-defense that Illinois restricts. So again, the firearms that he chooses for self-defense are restricted by Illinois. Final question before hard lunch break. They bring up Exhibit 191, Protect the Illinois Communities Act. They focus on the list of rifles that are banned. They say listed firearms banned are suitable for self-defense. Points to section of AR-type ban. It says limited firearms are suitable for self-defense. Listed firearms are suitable for self-defense. And then they say no further questions. McGlynn asks, Dad got you a shotgun when you were 8 years old? Did your mom say, don't shoot your eye out? They break for lunch. So back at it. All right, so expected defense witness number 1 this afternoon, defense witness number 2 Thursday morning. A little bit of conversation as they came back from lunch. Court back in session, but Watt is still on the stand. It's cross-examination. The defense gets up. Testified earlier about what's in common and what's uncommon. If you see a weapon, it's common. If you didn't see them, it's uncommon. Watt's not clear about the question. States pull up Watt's deposition showing that, quote, pump-style action shotgun common? Yes. Put numbers on firearms popularity? No. Use surveys? No. Expert on statistics? No. Keep records of observations in the firearms world? No. Warriors Creed course draws trainers from military and law enforcement. Most but not all, Watt says. Marketing video online? Yes. Training with Randy video screenshot was shown on the display. Image shows Randy Watt holding an AR-15 while he wears camo gear. State asks, does this image show civilian training course? Yes. Are you wearing a uniform? Not a uniform. Tactical style clothing and a helmet. Another image shown of Watt wearing a helmet, aiming a rifle. Wearing a police ballistic helmet, the state asks? It's a ballistic helmet. State shows deposition of Watt saying police ballistic helmet. Watt says it's not police issued. Again, distinction here, right? It's a ballistics helmet. He was asked if it was a police ballistics helmet. He says, no. Then they pull up the deposition of him talking about a police ballistics helmet. And in court, Watt says it's not a police issued ballistic helmet. Question about experience with manufacturers like IWI. They pay you to teach people to use firearms. Correct, he said. They are a member of NSSF. Watt didn't know. Watt says you can get pump shotgun with collapsible stock. Pistol grips are discussed by Watt and the defense. In pistol classes you teach 60 to 70 don't have that feature, correct? In traditional pistol course, correct. Makes distinction between the carbine course and traditional course. Carbine AR pistol course versus the traditional pistol course. There are two separate things that he talked about. High majority of self-defense cases, violence is very short-lived, correct? Watt says, correct. Amount of ammo needed? Watt says, every situation is individual. Pistol group, use limits recoil, correct? Yes. Rapid fire shots with limited recoil? Yes. Forward grips improve accuracy? Correct. Adjustable stock allows ease of use for different users? Correct. So a child could use their father's rifle. Plaintiffs object. McGlynn says child could be an infant or 16-year-old. State goes to Exhibit 218, focuses on adjustable stocks. Adjustable stock allows child to fire accurate rapid shots. Yes. So they looked at the deposition, I believe, of Watt, and that question was asked, and he just simply said yes. Flash suppressors improve vision. Correct. Then the state asks, if someone shoots in a dark movie theater, that improves their vision with a flash suppressor? Watt said correct. State has no further questions. They're done. McGlynn asks Watt questions in training, talk about real-world scenarios. He says yes, when it's legal and ethical, safety, moving in tactical ways, safe stance when weapon doesn't rise until threat is in sight, what legal standing is, best ammo for self-defense, gives training of penetration, wide variety of information, should be last resort, he says. McGlynn says, what if student says, I have a number of small children? Do you talk to them? Watt says we do. Safety, security of firearm important. Might decide different ammo or firearm. Yeah. Discuss with them safety of strong doors, like having your door that actually locks. They stress self-defense is only to bridge the gap until law enforcement get there. Would you recommend they get trained? Watt said absolutely. McGlynn talks about suppressors and the need for others in the house to hear. This is important. This has been highlighted by, Four Boxes Diner, for instance. McGlynn talks about suppressors and the need for others to hear in the house. Watt says it's very important. McGlynn then discusses common use test and the Supreme Court of the United States precedent. Watt says that he was not asked about that, but McGlynn said reason for Second Amendment, old people to defend themselves, people who are mobile or they're disabled, they're strong, they're weak. The judge says his wife's 100 pounds. Shotgun recoil too strong. What should she have? Watt recommends a carbine. McGlynn says when seconds matter and police are minutes away, people are on their own. Watt says as retired police, he recognizes that. McGlynn, the judge in this case, then asks what military wear. Watt talks about a helmet, eye covering, hearing protection with communications, body armor, military clothing, tactical clothes, tactical belt, boots. Belts hold traditional handgun, magazines, grenades, first aid gear, standard rifle, etc. McGlynn asks if they can go without any of that. No. Combat ready? Watt says ready and equipped. Different stages of readiness. McGlynn says as a member of the team limping, allowed to go to combat? Depends on the doctor. Fitness ready, mental, physical, physically fit, standard, depends on standard soldier. Special operation with higher scores. McGlynn then talks about just out of boot camp. Walk a distance, gotta have good sight. Watt says different things are needed. McGlynn asks about uncommon weapons, looking at his resume, the CV. A lot of training for SWAT, tactical certifications, scoring based off training, discusses chemical, biological, radiological warfare. McGlynn says most weapons discussed semi-automatic, single bullet per trigger pull, except shotguns with birdshot, etc. Anything you can wear and bear, McGlynn says. Nerve agents, bioweapons, etc. Not usual, but you can carry those. Those are arms. Omit electrical charge, inject a drug, maybe a projectile to blind or disable. Watt says yes. Watt's aware of developments that use frequency sound to incapacitate people. There are sticky foam guns, he says. Other similar developments fired from handheld. McGlynn says ninja stars can be used offensively and defensively. Yes? Yes. McGlynn also asks about tactical gear. Would be time to put on if in self-defense. McGlynn says when seconds matter, what do you recommend? Watt says he has staged weapons in his home because of threats that concern him. McGlynn asks about shotgun shells and various differences. With shotgun, 12 gauge, different number of shells depending on the shell size. Watt discusses differences between differences. McGlynn notices no self-defense training in 50 cal. Correct. McGlynn talks about the 21-foot rule. Watt says if someone's 21 foot or closer, they can get to you before you pull the weapon. McGlynn discusses training on stress, adrenaline. Watt says all kinds of things, including adrenaline. McGlynn also asks about psychological readiness for military. Watt says they go through tests to make sure that they are ready and not psychopaths. If so, they're discharged. McGlynn revisits Second Amendment, person's abilities. If someone is in a wheelchair, you might advise them to use a different gun than a 22-year-old marathon runner. Yes, McGlynn focuses on the Protect Illinois Communities Act and any device that might enhance the rate of fire. That's pretty broad. Yes. Require training? Yes. These are lethal, Watt says. This is part of the firearm, McGlynn says. Yes. On full auto, McGlynn says with 223 round, harder to control for average person. Watt says yes. Hard to keep accurate. We discourage rates of fire that can't be controlled. McGlynn points to the law. Manufacture, sell of electronic or other devices to increase rate of fire. Watt says that would be a bump stock. Other devices over years thought to improve the efficiency of weapon. McGlynn says no further questions. Attorney Mag asks about unusual weapons, anti-tank, anti-air, hand grenades. Watt says yes, very much unusual for civilian. Discusses shotgun shells. Mag discusses standard rate of fire, and then says nothing further. Watt released from full testimony. But then David Siegel gets up to ask some questions. A plaintiff's attorney asks about features of assault weapons and telescoping stock. Older child points to Andre the Giant and Dorothy the Gymnast or Dorothy the Dancer example, something that the judge earlier put in, but I wasn't able to include that. But regardless, would the gymnast be more or less likely to defend self with telescoping stock? Watt says more likely. 5-minute recess, court resumes. No more plaintiff witnesses. So they got through Pulaski, Ronkainen, and Watt, and Eby. All right, so plaintiffs had four different witnesses. So now it's time for the defense. And we're still on day 3 here. Day 3 was a long one. Court resumes. No more plaintiff witnesses. Discussion on entering exhibits. State's concerned. Some exhibits and asks to reserve right until the next day for the final review. Plaintiffs rest their case. Then the state defense calls Craig Tucker. Tucker grew up in the Rocky Mountain States, discusses his education, including master's in military studies, joined the Marines in 1981, retired in 2006, reached colonel, honorably discharged. After that, worked for the feds, helped transport weapon systems with paramilitary group, training, etc. Currently retired. He's left-handed, learned to shoot M16 right-handed, was a platoon commander. As a defense witness, explains what a platoon is, explains what a firearm team is, or a fire team rather. The fire team carried M16, M4 others carried ones with grenade launchers. Squad automatic weapon is auto fire for suppressive fire, designed in semi-automatic aid to kill, he says. Squad auto weapon is different than the M16, much heavier, discusses the barrel, etc. Discusses weapon system, including a Marine, and he says the firearm is a tool. So again, just pointing out there, squad auto weapon is different than M16, much heavier, and they discuss the barrel length. Tucker explains weapons for suppression, M16 on semi-auto, sniper aviation fire, etc. So again, he claims the M16 on semi-auto, and he kept saying that explicitly, is for suppression fire. M16 or M4, do they have to use full auto? No, Tucker says. Discusses Marine training. He trained others on M16, says semi-automatic is preferred. Trains on burst or full auto. Simulation training, 90% semi-auto, 10% auto. Discusses marksmanship training. Tucker says marksmanship training is important to get troops to react automatically to certain positions, differs from collective training. Tucker tells State that to train semi-automatic primarily, discusses more background in Marines, studied military doctrine, a framework across organizations for common understanding of what the units will do. Tucker says if you step outside doctrine, better have good reason. The state continues their questions. They discuss training in different units. Says that he trained others to use semi-automatic except in rare circumstances, and discusses combat experience in Iraq in 2004-2005, trained for specific missions. The state has defense with Tucker as their witness. They discuss combat his unit engaged in. He had contact nearly every day in urban combat. He said, quote, "You use a lot of ammo in urban combat, kill those that need killing, capture those that need captured, and open up lines." Tucker then discusses the Second Battle of Fallujah, described as very intense combat. He discusses room clearing, led with explosives, followed by 2 Marine general entry, followed by others. Says semi-automatic was used primarily, though there were adjustments, he said. Says prevented from flashbangs and other explosives. Innocent civilians could be there. Auto fire was used in place of explosive devices. So he does say auto fire was used in entering rooms. Different tactics used by other circumstances, depends on the circumstance, were required to use auto fire to clear rooms, Tucker said. Says room clearing is offensive, was personally in combat, used in M4, and he says in semi-automatic mode. Came under fire, near constant fire, assassination attempts, IED, and ambushed. He was wounded in Iraq in 2004 by an improvised explosive device. Tucker received awards, including Purple Heart, after 15 months in Iraq, went to train and certify troops for combat, asked why he's part of this case, says he provided opinion on differences between the semi-automatic and auto. Exhibit 213 is shown, a response to Eby report. Eby, this is interesting, Eby was Tucker's gunner and combat buddy, he said. So Jeff Eby knew Colonel Tucker. Colonel Tucker knew Jeff Eby. They were on opposite sides of plaintiff and defense witness. But he says Eby is one of the finest infantrymen he knows, again calling him his battle buddy. Eby testified for plaintiffs in this case Monday. Tucker discusses others that he would get advice from. They didn't always agree on plans and operations. Tucker says he would personally make weapons decisions, would make decisions about whether to attack a mosque in Iraq with significant history and culture, needed to make the right decision, he said. The gunner would provide recommendations. Tucker made the final decision. Tucker says he didn't review law at center of the case. Again, admits he did not review the Protect Illinois Communities Act. He did not review anything else other than Eby's report. Providing opinion based on experience, that's embedded in him, he says. He says Eby's report about importance of automatic fire in combat and lack of understanding of a holistic approach within 2 minutes of suppressive fire says that the rifle is not designed for that and increases malfunction, and says it's logistically insatiable. It might be unstable. Again, rough transcript. I'm feverishly in the courtroom posting away just so we can get this out there for you guys, because we're not going to have the official transcript from the state until mid-December. Tucker says auto fire at that level of 700 to 800 rounds per minute is not realistic. Says go through ammo carried rapidly if you are always full auto. Changing mags leaves you vulnerable. Tucker said full auto isn't a defining feature of combat rifle. Had issue with pure, and this is peer competitor. It should be peer competitor. I kept hearing pure, but peer competitor terminology. Tucker says he never fought a peer competitor. That would be Soviet, Russia, or China. Tucker says going full auto, even with peer competitor, has a host of challenges, and discusses logistics, the importance of that, and moving ammunition around. Says auto fire loses too much ammo. Tucker tells the state he wouldn't advocate removing full auto from military. It's an option of last resort. So the state asked, would you recommend getting rid of full auto in the military? And Tucker said no. Again, this is all seems to be answering the question of the 7th Circuit U.S. Court of Appeals saying that the state would have a likelihood of succeeding on the merits of this because the AR-15, semi-automatic only, is too similar to the military full auto firearms. Yeah, they might look the same, but as we heard with some of the other testimony, that's not necessarily the case. But back to this. Tucker goes on to talk about how he would not advocate removing full auto from military. It's an option of last resort, he says. Goes on, are there other options for suppressive fire, mortars, machine guns, M16 on machine automatic for good shooter, etc. Says he was asked to leave the Marines after an affair with a subordinate, led to alcoholism, lost his federal job and security clearance. Hasn't drank since 2013, didn't have reward strips, no further questions at this time. So again, the defense brought that out themselves about how Tucker left the Marines. Says that, asked to leave the Marines after an affair with a subordinate, led to alcoholism, lost his federal job and security clearance, hasn't drank since 2013. Interesting to see that. So no further questions at this time. Plaintiffs questioned Tucker, reiterated he wouldn't recommend getting rid of full auto from military rifles. Then they say no further questions. McGlynn and Tucker discuss Notre Dame and rugby. McGlynn says that his brother said don't ever ask someone to tell rugby stories on the record. He thanks Tucker for his service and releases him from the stand. Wraps up for the day. So again, the day cleared up there with day 3 of the state being challenged on the gun and magazine ban. All right, so back at it here. Again, the live stream might disconnect, but we are going to upload this entirety for you to watch without any interruptions. All right, so hopefully it does connect and we get you back on live. But let's take a look now at day 4. I'm starting to feel it on my voice here. So day 4. All right, again, these are the posts on X. I wanted to get this all in one video for you guys, so there's just this so you can go through and review all the text here if you want, or you can listen to it however you want to listen to it. But day 4. All right, so they wrapped up with Tucker, the first of the state's witness of day 3. Here we are for day 4. That bench trial, McGlynn enters. He says one issue in the record may have to be sealed. Clears everyone out of the courtroom, including reporters. All right, start day 4. But he leaves the litigants in to discuss the issue. Now, I'm speculating here. It might be that last question the defense asked Tucker about why he left the military early due to an affair. All right, so I think that's what they may have decided they're going back to seal. So, after that, again, that's just my speculation. Not sure. I guess we'll have to wait and see what we'll see what the official transcript says. Again, we won't have the transcript out until mid-December. That's why I'm doing this, just to get this all out, so you guys have access to this. If you didn't want to go to my X page and filter through all of that. And again, I will also post each one of these day 1, 2, 3, and 4 in one page each, so you can go through and look at this yourself. But anyways, all right, so back at it here. We've got the courtroom reopened, back on the record. Defense calls their final witness. It's Jason Dempsey, Lieutenant Colonel. Dempsey explains his family's history in the military. He went to West Point, qualified with the M16, ran a basic training unit, discusses terms of squad, platoon, company, battalion, brigade, division, and corps. Reiterates M16 training with semi-automatic and full auto. Burst mode described. Selector switch explained. Training on only semi-automatic firearms. Or training on only semi-automatic. So he claims that they only trained on semi-automatic. He was trained on semi-automatic, never on full burst or auto. Learned about military doctrine at West Point, gives his definition as fundamentals of policies to follow, where doctrine ends and technical manuals begin. Says at West Point, he learned about joint doctrine that guides Army, Navy, Marines, and now Space Force. Says military ranges up to 530 members. I've seen that countered in some other areas. Dempsey says cadets would carry doctrine with them. Exhibit 263 presented. Infantry Rifle Platoon and Squad from January 2024. He graduated West Point in 1983. Reported to Fort Benning in Georgia. Trained at Airborne School. Weapons trained on all assets for infantry, M16, other firearms, anti-tank systems, AP4, exposed to 60mm mortars, 120mm mortars, 155 howitzer, 50 cal machine guns, vehicle-mounted systems, 25mm cannon, couple of machine guns, weapons with built-in extendable tripod, belt-fed, spare barrel. He talks about that being what a machine gun is. Rate of fire requires the barrel overheats, and machine gun does not refer to M16 or M4. So when he says machine gun, he's talking about these much bigger guns that come with a separate barrel so they can change that out, and it's belt fed. He's not talking about M16s or M4s when he talks about machine gun. Is that a point for the plaintiffs? Defense asks Dempsey about Ranger School, put in harsh environment, woods, desert, mountains, swamp, all different phases. They're all tested and graded, carrying different firearms. Have to pass to advance. He did. He graduated Ranger School in 1994, stationed at Fort Bragg, not Fort Liberty. Says M4 is a shorter barrel, more convenient, has semi-automatic and burst mode. Dempsey describes duties at 82nd Airborne, prepared for projected invasion of Haiti, qualifies platoon on weapon systems with dry fire, plain fire, external evaluation, exercise in different environments, raids, ambushes, and standard attacks. Didn't ultimately invade Haiti. He said he was on a plane with his M4 before Carter and Powell made a deal, and then the plane turned around. Some history I wasn't familiar with. The defense asks Dempsey about deposition of developing doctrine, says since deposition, the chief of staff invited him to West Point last week, where he reviewed, edited, and offered suggestions. So during deposition, he said he wasn't involved in helping with military doctrine, but just last week, he says he was asked to go help with some military doctrine. Dempsey says he was issued new firearm, M4, when transferring to different base. Had semi-automatic and burst, the M4 did. Discusses airborne operations, raids, helicopter insertions in compound or urban environment. Had full suite of weapons. Ranger regiments included Barrett sniper and 84mm rifle. He would train against specific opponents for certain threats, always trained in semi-automatic mode, he says. He discussed other training for different schools. At Bradley Fighting Course, Dempsey said, trained on vehicles, different machine gun, cannon, and other systems. Commanded company with up to 160 people, trained to fight in Iraq pre-9/11 and invasion as deterrent to Saddam. Trained on M4 only with semi-automatic. Again, he reiterates, sent to Iraq, carried M4, carried M9, discussed training in Kuwait for full-on company-level maneuvers, extensive trench lines, trench live fire with M4, hand grenades, tanks, other weapons, planned large-scale breaches, demine, destroy other obstacles, etc. Dempsey describes training for close quarters. After he gave up command of company in July of 2001, asked to teach at West Point, spent one tour teaching cadets in political science, got a doctoral degree from Columbia, followed that, went to West Point to teach as instructor and professor. After Iraq war kicked off, Rangers were then set, cadet training as an officer, he says. Defense questions of Dempsey continue. Deployed to Iraq in 2005, was unique, political and economic oversight of how to run Iraq. Tested with handling conflicts among the Kurdish and Sunni groups. He says he carried an M9, patrolling with Blackwater with an M4, with National Guard, carried an M16. After, he went to Fort Leavenworth studying joint doctrine, military history, operations, tabletop war game exercises. From there, and again, they spent a lot of time with Dempsey, the defense did. From there, Dempsey says he was assigned to 3rd Brigade Mountain Division, trained for deploying to suburbs of Baghdad, individual marksmanship, no more M16s in inventory, so he carried an M4. Sent to Afghanistan after training, focused on helicopter insertions, mix of urban environments. As operations officer, planning, training, and managing deployed operations. Once deployed, he sets up a headquarters. Defense questions of Dempsey continue. Plans mission for Afghanistan. But then we have a brief recess. Back to it. Defense continuing their direct examination of Dempsey. Talks about Afghanistan. Task force chosen. Served as senior leadership in the reshuffling assets. Then in 2009, Task Force Spartan. There he managed to review operations for plans and attach aviation squad. Allocated assets for unit level operations. Counter IED elements, etc. Dempsey says that he'd adhere to standard operating procedure and other guidance, things decided before they got there. Says he operated in the run-up to the first Iraq presidential election, the Bo Bergdahl AWOL situation. He said troops fired weapons probably daily, carried M4, full suite, and probably 2,000 rounds, I think. They fired at least one a day, 6 times a day. Fire, they would receive fire, they could be hit by IEDs. Can't quantify the number of rounds. In 2009, stayed in operations for pre-deployments, new orders, individual training, and then relinquished role in the summer of 2010. Extensive after-action reviews. Rotated out of the division. The White House program he was accepted to take Americans to inspire civic involvement. He worked with first and second ladies to design and launch joining forces to mobilize business and civil society to support veteran families. Then put name in to be an advisor, then on White House task force for veterans and families on housing and overhaul of veteran transition programs. Then he went to the 101st Airborne at Fort Campbell, commanded advisory team there, prepared for deploying forces. Training was a team at squad level, basic weapons qualifications, and ad hoc squads. Dempsey discusses training on marksmanship with the M4, only trained on semi-automatic mode. A lot of chaos in subsequent deployments to Afghanistan. Advisory team for Afghan border police. Conducted foot patrols, not regularly, a few times a week, he said. Carried the M9 service pistol and M4. Redeployed spring of 2013. Then took job with chairman of Joint Chiefs at Pentagon. Asked to travel abroad in 2014. Somebody in the live comment says this is irrelevant. There was a ton of background on these guys, their resumes, all the different trainings they've been involved in. I don't know if that was just to build expertise, but this was a trial. This was straight up a trial. It's not like the appeals court where each side's given 10 minutes and then that's it. No, this was a trial. They had to build that record, and all of this is part of the record. Back to it. Retired from Army 2015, Lieutenant Colonel, had a lot of fun, been in 22 years, had 2 kids, time to do something different, he said. Now focused on veterans, higher education, part of the Veteran Advisory Council for productive discussions around weapons, focused on suicide, firearm prevention, talks to organizations with that focus. Dempsey now asked to focus on role in litigation. Exhibit 214 presented, asked by state to review use of firearms, review reports, drafted reports, addressed utility use case of M4 in combat and use in firing modes, based his opinion on documents and how they had been employed in his experience. Declarations entered into evidence, says infantry issued M4, before that M16, says always trained in semi-automatic. He said that at least 5, 6, 7 times. McGlynn says, haven't we gone through that before? Says no one's challenging his expertise. says that he wants to hear his opinions. So Dempsey says he fired in semi-automatic as most effective and reliable to place well-placed fire. With burst, second and third bullet thrown off. Weapon can jam. Machine gun's meant to be rapid fire. M4 is not, Dempsey says. In Iraq, he says Saddam had large army and could pose existential threat. Discusses peer threat. Dempsey says facing certain forces, most effective form of fire needed to kill enemy. Precision fire different from suppressive fire. Suppressive fire should still be accurate. Says best way to deliver accurate fire is semi-automatic mode. Dempsey says doesn't recommend M4 for suppressive fire. Discusses using team rifles for suppressive fire at platoon level. Different squads use 2 M249 weapons. Gives movement capabilities with best, most accurate. The M249 jams. Won't use full auto with M4. It could jam. Always only trained in semi-automatic, he said. Expected semi-automatic mode engaging enemy with M4. Never used burst or auto in battle personally. So no further questions from the defense. The plaintiffs take their turn to question Dempsey. Asked about personal ownership of a SIG AR semi-automatic rifle with 30-round magazine standard. Purchased additional mags. Has attachments. Added pistol grip. Barrel shroud. Flash suppressor. Dempsey says he reviewed Illinois' gun ban law. Agrees Illinois bans rifles he owns for personal use. Says his opinion. Again, this might be a point for the plaintiffs. Says his opinion is for training, not banning outright. He wants training and accountability. This is the defense witness, Dempsey, saying his opinion is for training, not banning outright. He wants training and accountability. Says he's not an engineer, gunsmith, or has trained others in private life. He is not a self-defense instructor. Dempsey says he's trained others for hand-to-hand combat. Says he didn't engage with peer enemy in combat, but was in combat. Says he never trained troops for burst or full auto. Plaintiffs point to Dempsey's deposition to that effect. Says Army's not trained for burst or full auto. Deposition focuses on Dempsey saying that he never trained infantry for full auto or burst. Deposition later says he trained others exclusively on semi-automatic. Says the Army not prepared to use full auto. Dempsey says the Army's not prepared to use full auto. Says M4s don't have full auto. Says don't train on burst, and Army not prepared to use bursts. He never recommended to any Army that they issue semi-automatic only rifles. Again, he was asked by the plaintiffs, have you ever recommended to the Army that they only have semi-automatic only rifles? And Dempsey says he's never recommended to the Army that they issue semi-automatic only rifles. Dempsey disagrees with defendant's witness, Colonel Tucker, that Army shouldn't get rid of full auto or burst modes for rifles. Again, Tucker, a defense witness, said that he does not recommend getting rid of full auto or burst from military. Dempsey disagrees with that. Dempsey says he's discussed how two others in special forces about full auto and burst being insufficient. He says he's reviewed documents and depositions about new combat rifles being adopted. He's asked about his opinion on rifles without knowing of the newly adopted XM7. Apparently, the military went ahead and adopted a new XM7, which is full auto. Now, this came after Dempsey retired. But asked about opinion on rifles without knowledge of newly adopted XM7, correct. Has full auto capable rifle. He says, I'll take your word for it. Could take a decade to implement, he says. Exhibit 28 shown. It's an article about the XM7 rifle adopted by the Army. Rifle depicted does not have burst. No explanation why Army adopted full auto if full auto isn't necessary, correct? Then he talks about Army acquisition process. He acknowledges all other Army round world issue their Army select fire. Dempsey says that he would recommend semi-automatic only. Discusses colloquial, the term big Army. He says he never made such suggestions to big Army. Plaintiffs discuss H&K full auto firearm. Not familiar with that. Plaintiffs discuss Dempsey's personal experience in room entry. The deposition says non-contested. Reads rest of the question from Depot. The deposition at McGlynn's request. Dempsey says he reviewed room entrance via video. Not in deposition. Reads deposition response. Says no. Acknowledged he never personally cleared a bunker. Discusses doctrine. Says attack while on patrol by aircraft. You give a wall of fire. Exhibit 32 is presented. It's an infantry rifle platoon and squad. Cited in Dempsey report, document discusses in hostile attack from air, you respond with, quote, all available automatic weapons. Doesn't disclose what weapons. Dempsey discusses final protective line. He recommends any fire that doesn't render self-combat incapable by jamming a weapon. He suggests semi-automatic. Then we take a brief break. Coming back to it, on the record again, me in the courtroom going crazy on my phone, sending out these posts. So what we're doing here, we're on day 4 now, reviewing this, just over 2 hours of this recording. Back on record with plaintiff's cross-examination of Dempsey. Back to final protective line discussion of Exhibit 32. The document says, spare no ammo in repelling enemy assault. Acknowledges no doctrine says do not use burst full auto. Dempsey says best not to use mode that could jam. Acknowledges document doesn't say anything about using only semi-automatic rifles. Dempsey still recommended using only semi-automatic. Asked about final line of defense, Dempsey says soldier must do what they can to stay alive. Asked about salvo and other reports, says he's not familiar. Again, says doesn't recommend burst or auto as a waste of ammo and jamming. Exhibit 32 presented. Plaintiffs ask about the time of suppression and use of automatic weapons with no limitation of what weapon. Dempsey says M4 wasn't full auto at the time. Plaintiffs move to strike that. McGlynn overrules that. Exhibit 33 presented. Armor and mechanized infantry document features discussion of time of suppression from a sustained rate of fire with automatic weapons. Dempsey says M4 is not full auto. Plaintiffs say document doesn't say a word about semi-automatic. Plaintiffs say that Army has now issued full auto rifles. Dempsey says he has no opinion if that's why they moved back to full auto. Exhibit 31, Dempsey's report about personal ownership of semi-automatic firearm, 6 Sauer 516 replica to M4 without burst function, doesn't know material of civilian rifles, metal treatment, trigger group materials, etc. Says he hasn't tested abuse testing on it, didn't do any scientific testing to prove civilian rifles same as M4 without burst. Plaintiffs ask about standards needed for military firearms. Exhibit 36 is shown, lays out specs for military firearms needed for select fire. Dempsey says he's not aware of that. Discussion of standards for civilian arms, he's not aware. Discussion of standards for military spec, says he's not aware. Says he's never helped with doctrine in deposition. That changed in today's testimony. We touched on that earlier when the defense brought that up. Dempsey talks about need for well-aimed fire, says he's thankful he fired no rounds in combat in Middle East. Asked about side-by-side testing of firearm modes, Dempsey's deposition is then shown. Question asked again. Defense objects on vagueness in the deposition raised. McGlynn overrules that. Dempsey says answer to vague question was no. Or answer to that vague question was no. So interesting kind of back and forth there. Guess you had to be there. Back to Dempsey deposition discussion about burst and semi-automatic comparisons where semi-automatic is better. Plaintiffs say that he's never conducted such experiments. Says he's only engaged in full auto a handful of times. Asked about hypothetical of China invasion, he would recommend civilian arms depending on manufacturer. Deposition says auto fires wasteful from rifle when machine guns available. What if machine guns not available? The plaintiffs ask. Dempsey says accurate fires needed. Says machine gun not needed for suppression. Exhibit 31 shown, discusses automatic riflemen. Dempsey report says no need for automatic riflemen. If killed, burst is available, correct? Dempsey says no. Dempsey says those left can get to the automatic rifleman's weapon. Says burst fire gets one round close to the enemy, rest is just noise, Dempsey said. They discuss peer opponents in Dempsey report. He says automatic rifleman is always available, but that can be lost, he acknowledges. If automatic rifleman weapon is destroyed, M4 is left, soon to be the XM7 full auto rifle, correct? Dempsey says he's on a board of the gun control group Everytown. He's not aware of the amici brief they filed in the Beavis case. Nothing further from plaintiffs. Break for lunch. After lunch, court resumes. Defense redirect of Dempsey begins. Questions personal ownership of semi-automatic rifle. Says it was a commemorative rifle from his time overseas. Says he does not use it for self-defense. Asked about the technical specification knowledge. Says that he was able to command troops without knowing that. No further redirect. So, McGlynn addresses Dempsey. Dempsey's the final witness here, all right? McGlynn addresses Dempsey, says he expects to go, he goes to sleep every night thinking about how to protect people. Dempsey acknowledges that. Judge says Dempsey surely understands the turmoil and anguish troops undergo, led people into confrontation, and has important experience. Asks a few questions now. McGlynn asks about peer opponents. What about Third World? Would U.S. be considered superior to that? Not particularly, Your Honor. McGlynn says it appears Dempsey is urging for well-placed rounds and that semi-automatic's not useful, and with full auto, it sprays all around. Dempsey says yes. To have full control, must have specialized weapon. Yes. Asked about magazines needed. Must be well armed. Correct. Training about firearm upon enemy. Do you limit or keep firing to neutralize enemy? Dempsey says you want to hit and kill the enemy. Depends on how good marksman is. McGlynn says a lot of time is spent training soldiers to be good shooters. Correct. Firearm protective line. Have to hold this line or in serious trouble. You could lose the engagement. Dempsey says correct. Sometimes no other way out. McGlynn says, what do you say to fellow citizen in similar position? Peer opponent or greater opponent? Recommendation? Dempsey said he would take 5 minutes to find weapon and keys. He says it's quicker to leave the house with his phone. Asked about his semi-automatic firearms. Useful for self-defense? Dempsey says no. Can't imagine scenario using such. Wouldn't recommend, he says. Untrained shooters, other weapons he would pick up, Dempsey says. So interesting. When they're talking about peer opponents, McGlynn equates that to home defense. Again, McGlynn's questions in all of this, I think, is something that probably should be highlighted all on its own. The separate video, who knows? How many invaders might change what you recommend? Haven't thought of it, Dempsey said. What about fatigue? A shotgun? Recommend smaller shotgun. Important to train with weapons focused on accountability? Correct. I stand by that. So he's asked about, making sure people are trained and accountable with their firearms. He stands by that, he says. You don't like full auto in confrontation to preserve ammunition and take better shots? Dempsey says yes. Thank you for your service. No further questions. Dempsey dismissed. No more witnesses. So that was it, right? And here we are at the tail end of this 4-day trial. This is a rough transcript. The actual transcript's not going to be released until mid-December, at least how I read the court docket. But then the litigants, they went on to discuss other exhibits to submit, some set aside for closing arguments. Start with the plaintiffs, so we'll hear the closing arguments now. Case addresses constitutional question whether commonly owned semi-automatic firearms can be banned by Illinois, the plaintiffs say. They say that it doesn't stand constitutional muster. They say pistol grip, forward grip, collapsible stock, barrel shroud, threaded barrel, changing magazines, more rounds, useful for self-defense, and is not a militaristic feature. They note that the state's expert, Tucker, said changing mags leaves you vulnerable. Plaintiff's expert, Watt, said people are on their own in self-defense. Banned firearms are useful for self-defense, they said. They say that such guns with features are ideal for self-defense. They say no military in world issues semi-automatic only rifles. Military spec requires burst or full auto. Even Tucker said don't prohibit burst or full auto from military. Plaintiffs continue in closing remarks, say firearms regulated by the ban are commonly owned for self-defense. Their features are commonly owned for lawful purposes and train with defense in mind. Experts recognize use of such for self-defense. As Pulaski, the only Illinois resident to testify, the owner of Piasaw Armory, recommended semi-automatic firearms for self-defense before the ban. Shotguns with detachable mags or magazines with more than 5 rounds are common for self-defense, provided lengthy amount of documents to support that, the plaintiffs say. Court should find Protect Illinois Communities Act unconstitutional and enter a permanent injunction against Illinois from enforcing it. Plaintiffs end their close. State's closing. They say the key question is about material difference between civilian and military weapons. Experts agree that military trains with M16 and M4 on semi-automatic. Other facts in focus, both have grips, adjustable stocks, flash suppressors, etc. With high rates of fire to kill enemies. Features are same, except selective fire switch. Quotes Eby, quotes Ronkainen about innovations for AR rifles, but not any changes to make safer to civilians being shot at. Says plaintiffs admit both civilian and military fire same ammunition. Other facts: Illinois law prohibits .50 caliber, rarely sold, can hit target from a mile away. The defense says that Watt says keep AR pistols out of traditional pistol training. No one told us they were used for duck hunting. Said that hearsay from Pulaski about why people buy them. No evidence provided, they said. Ronkainen said demand increased after federal ban lifted. Eby said he prefers AR-15 for self-defense only because full auto isn't legal. Finally, the state says plaintiff's witness Watt didn't provide real evidence, just anecdotes from people who self-select for his Warriors Creed course. State says banned semi-automatic guns aren't suitable for self-defense, says it fits dangerous and unusual weapon, and definition between what's good for civilians and police. They urge the state, the judge, to uphold the law, and they end closing. All right, so McGlynn says it's an important case. And this is where we get to the end, and McGlynn, at least from my perspective, kind of threw a bit of a curveball here. McGlynn says it's an important case, expects filings on history and tradition, says when the case started he questioned where this will go. He said to tour the East St. Louis area, he called sacred sites all around, says important to recognize people sustained losses. On 8th Street, there was a hospital where he was born. He projects an image from 1917, and it says 70 here, but it was 1917 rather. Let me see if I can pull this image up, because this is the image that he projected on the screen. He pulls this image up from 1917, the race riots, and the arrow, and you can see the debris around there. He said to him it looks like Vietnam, but the arrow pointing to that building, that's the building everyone was in the courtroom. That's the building everyone was in the courtroom. Again, just fascinating to have him pull that up. But McGlynn says it's an important case, projects that image, looking south, shows burned areas from a riot. A man's house was burned for being black, he said. Sacred sites. He says, end of court parking lot was old Broadway theater. Word got out, black families were hiding there, burned down. Nobody escaped. During course of riots, 100 blacks were armed, shooting back. Rioters said that's not fair. They went to the National Guard to complain. The Guard then gave safe passage to the black victims across the Eads Bridge. Another area, line of demarcation, he says. Points to the picture, arrow of building surrounded by debris. Building his court we're in now. Says it looks like Vietnam. Says everything families owned was burned by the mob. McGlynn said all black houses set on fire, one by one, as people escaped to other houses that were also burned. One man beat in the head with an iron pipe with a noose around his neck. Not long enough to hang, so they dragged him. 4th and Broadway, McGlynn says there was a Fountain of Youth Park. St. Louis Reporter sees bodies with one guy being pulled to hang, with people saying pull for East St. Louis. The mob prevented ambulances from helping, stopped streetcars and dragged blacks out and beat them, he said. 4th and Division, they found the body of a kid cremated, hiding. Others hiding in home nearby, frightened. Fire from house to house while theirs was collapsing. Horribly burned, community lost everything. McGlynn wonders if they tried to make a stand, poorly armed, fleeing from mob, jumping in the Mississippi, off bridges for certain death. What if they had some of these weapons? Who knows, he said. Then he discusses Tulsa, Oklahoma, I believe 1921. Black neighborhoods, very nice. Same thing happened. Mob set upon them, burned and killed. More recent, Aurora, Colorado, international gangsters, well armed, going into attacking doors in an apartment complex. Video occurred 30 days after police were called, he said. They were on their own. Maybe a little kid hiding under the bed. Mom or the bad guy's gone. Part of our history, he said. The judge, the federal judge in this case, says going to confront evil people. Going to be called to defend yourself, your community. With respect to what we have here today, the Second Amendment has nothing to say, he said, some may feel. She's too old, lost her luster, maybe too senile. He says before leaving East St. Louis, stop by these sites. Never know what's going to happen to you in your life. That's why this case is important. He doesn't question the sincerity of any of the litigants on either side. Then he gives 30 days to submit briefs, and we are adjourned. So there you go. Oh, that's 2 hours and 15 minutes. I will link to each one of these: day 1, day 2, day 3, day 4. These were rough transcripts of the 4-day bench trial for the challenge of Illinois' gun and magazine ban. Greatly appreciate you guys being here. Not sure how the live stream did, but this will all be on one show. All right, so one full 2 hour, 17 minutes. That's what it's going to be. All right, so just wanted to get that out to you. All right, because we're not going to get the actual transcript until mid-December. What time is it? It's almost 6 o'clock here. All right. Hope you enjoyed a special Sunday stream here with Bishop on Air. Greatly appreciate it. Yeah, be sure to like, subscribe, and hit that notification bell, all right? Make it happen with Bishop on Air.